Someone make it make sense.
Probably a couple.
The snow, it melts the soonest when the winds begin to sing. Any of you guys know that song? I was just finding this footage here of Yuri Bukhenik and literally had to scroll through tons of testimony about the snow melting and how fast the snow was melting and when was the snow melting, what happened when the snow melted. And I'm like, oh my God, I missed such an opportunity during this first trial because there's a song that is perfect called The Snow That Melts the Soonest. And I'm like, I could have been singing it the whole time. But anyway, that's why we've got round 2 coming right up, right, guys? Here in less than a month. Shout out to Meg, who's first. By the way, Meg, did you see that we had Delphi earlier with you got plenty of shout outs there because it was upon your request. So Twiz, did your color change? Your color changed. How is it orange and not brown? I'm confused. That's throwing me for a loop right there. Usually Twiz's tea is brown. Y'all are funny. We've been having all kinds of like wildfires here. Have you guys seen that shit on the news? Pretty crazy. Also, huge shout outs to our new members from earlier today. We had DB, we have I Love Elephants and Kayla, and also shout outs to our other members. To my knowledge, we've got Franks, who was the very first member. We've got Iowa, and we've got Sudi. And by the way, Iowa of Iowa's Backyard Cam has 2 recently posted amazing videos. You guys need to all watch them. One is Squeaky the Squirrel. Squeaky's home in the tree, and she's coming out of her home. And by the way, Squeaky the Squirrel, for members, guys, where you have the badges for like the amount of time, at the 2-month mark, the badge is legit actual Squeaky the Squirrel when Squeaky the Squirrel was a baby. And then the other funny video too that Iowa just posted was Batcat like approaching a raccoon, and it's playing like the Danger Zone music. Oh my God, it's so fucking funny. They are amazing. So check Discord. What are we hoping is true? And why are you orange? So let me I need some more water. BRB, hold on. I drink a lot of water. I like water. What are we hoping is true? So yeah, there were new Karen Reed docs that came out today. I had time to grab one of them. There's also a hearing tomorrow. And actually, real quick, let's do this real quick. Hang on. Okay. Let's do this real quick because it's not enough to warrant its own stream here, but oh, we have another new member. Welcome, Meg. Awesome. Love it. Love it. Do feel free to post in the Discord any requests that you have for members only, perks, live streams, what have you. You know, or you can put it in the chat either way, but welcome to another new member. Yay. We love it. And Meg is gifting memberships. What on earth? You're the first person to give memberships. I'm going to lose my mind. That is awesome. Thank you so much for your generosity and for being awesome and amazing. That is sweet. We love it. Yay! Squirrel Crew! Woo! That's super exciting. I feel like a real YouTube person, like, you know what I mean? Because I'm like so used to seeing like members shit in people's like channels, and it's just really crazy to see that happening. Like when I'm like, whoa, like holy crap! I'm just let's see and make sure all these get starred, like fancy put it in the starred category. Okay, so yes, right here, here's the one, so. Flash was gifted a membership. And that's also why I started the memberships out at 99 cents, because it's like you can't go any cheaper than that. If they offered them if YouTube let you do a penny, I would have done that. Because I wanted to make sure that, you know, everybody could, you know, hopefully afford to become a member if they want to. You know, and I have like the 3 tiers just because it's like that's sort of what YouTube recommends. And, you know, anyway, so the other thing is like, once you, like you can't edit certain things or add certain things on after you make it a level. So I just was thinking ahead and made extra levels. But anywho, so hi Flash again. No, you can't stay, but you wanted to come say thanks. Awesome. So that's awesome seeing you guys in the chat looking like members. That's so cool. Okay. So, but here's the thing. So here's the big news here on this. So real quick, because again, this isn't going to warrant its own separate stream. Apart from March 3rd, so today, we have the order regarding sealing or redacting filings. So this is Brian Kohberger, right? So, all right. Here we go. So this is good news. The party's pervasive practice of filing material under seal in this case has become the norm rather than the exception. True. Rather than seeking to redact discrete sensitive information, entire documents are filed under seal. In addition, much of the material the parties seek to seal is already in the public domain or is simply not confidential or sensitive. Footnote 1. And footnote 1 says, likewise, the party seeking to seal a document that contains the entirety of the information sought to be sealed in the title of document is an exercise in futility because the name of the document. Yeah, I agree. I agree with this. The name of the document, which contains sensitive information, once filed, is publicly available register of actions. I agree. I mean, y'all know I'm not Judge Hippler's biggest fan, to say the least, but I do agree with this, and I appreciate this. Okay, this approach runs counter to the public's First Amendment rights to know what is going on in its courts. State v. and citing State v. Clapp. Consequently, the court will look with scrutiny on requests to seal documents simply because they purportedly contain facts that are not public, but that nonetheless will likely come into evidence. ICAR 32, right? The Supreme Court adopted ICAR 32 to define when public access to judicial records may be denied, including through the redaction and sealing of court records. Twiz is also a member. Awesome. I agree. It's so much easier to see people better in green. I totally agree with that. It totally is easier to see. Yes. So, okay. ICAR, including through the redaction sealing court records, to warrant sealing redaction materials must meet specific criteria set forth in ICAR 32 as to allow the court to make findings necessary to justify its decision to withdraw the material from public purview. Moving forward, the court will require the parties to adhere closely to this rule and only seek to seal and or redact material as provided thereunder. Yay! In addition, all proposed orders to seal or redact will specify the basis under ICAR 32 for which the sealing or redaction is warranted. Awesome. A bare citation to the rule or conclusory summary without an individualized, rigorous, factual, legal analysis of the basis for seeking to have documents sealed will result in a rejection of the request. Okay, like, again, don't like Judge Hippler, but you know what? This is good news. Like, he's like smackdown, right? Judge Hippler smackdown. So, okay, further, the parties must also seek the least restrictive method to protect information that should be or is exempt from disclosure. For example, that despite the court's concerns, oh, you know, it'd be funny. What if I read it like Dracula, Count Dracula? Sorry. I don't know why, but I said, I can't see now. I can't do it now that I'm trying to. I said, like, for example, I don't know. Now I can't do it. I did it on accident, the Count Dracula, and now it's all ruined. Okay, keep reading. For example, despite the court's concerns being expressed previously, the state continues to seek broad orders sealing entire documents to protect the identity of individuals rather than simply using initials. Yes. Or requesting that a redacted version be made public that discloses only initials. Accordingly, the state's request to seal filings writ whole are denied. Woo! Except as otherwise noted regarding certain exhibits containing grand jury and testimony or other exempt records. Rather, those filings have been redacted by the court to refer to certain individuals by initials or family members of the deceased victims by their nature of their relationship rather than the name. The original filing will be sealed and the redacted versions will be made public. In addition, the court has redacted portions of the defendant's filings that contain grand jury testimony. Okay, so what does this mean? So here's the thing. So there's this one. Now, we already went over this, I believe. I mean, there's not much there, right? This is the order temporarily sealing the February 24th. Now, what the February 24th filings, those are the ones that we were waiting for. Those are all the motions in limine, right? Including stuff pertaining to the death penalty and being autistic and all kinds of stuff. So here's the thing. Let me zoom in. Zoom, zoom, zoom. So here's the deal. We don't know yet what all is going to come out, but basically this order right here said temporary sealing all the filings. Oh, there was a fuck ton of them, right? So it's sealed pursuant to ICAR 32, pending this court's determination as to whether sealing is appropriate. Okay, so we had that. Then we had this that just came out. So what this doesn't, well, we don't know yet is what is he determining, right? Essentially. But that he's going now. Having said that, let me check the case summary. But regardless, this document right here does not specify which of those February 24th filings are going to be unsealed. But let's check the summary. Okay. I know that many of you guys like me check this all the time. I haven't checked it in, I don't know, a few hours. Sad. Okay. Scroll. It seems like though, whenever I like don't check this shit for like a couple hours, that's when shit happens. And I'm like, really? I literally, it's been 2 hours, you know. Okay. So all these 224. Okay, so these are the ones that we covered, right? These ones here, we covered these. These motions, these 4 right here that are not yellow, okay? So guys, look. Okay. So there was a subpoena issued. There's the order temporary sealing filings, order sealing defendants, unredacted motion in limine number 5, order regarding, and that's what we just read. We just read this order regarding sealing or redacting filings. Motion to redact or seal newly filed records. So what I don't see is this. Here's what I don't see. Here's what I don't see. What I don't see is a change to any of these documents from February 24th. You guys see what I mean? Like these are all locked still. So, you know, I don't know that this is like, I don't want people to get their hopes up that, and I'm saying that for myself as well, that this order that he just came out is like, okay, we're going to unseal those, because it doesn't look like that is the case, because that this is the same. These are all locked. So, and we do have, this was updated, this case summary was updated today, and we do have unlocked other new things here from today. So if they were going to unlock, as it were, those filings from 224, it would look like that on the case summary. Could that change? Of course it could. But at this juncture, they're not unlocked. So in other words, what does this mean? it means that the next thing that we should expect to see that we can open and read, right, is this subpoena, deuces take 'em, which I don't know why that hasn't posted yet, but it hasn't. This order, oh no, wait, that order is already posted. We'll go over that too real quick. Then motion to redact or seal newly filed records, motion for leave to file additional expert witness disclosures, supplemental request for discovery, motion, and another motion to redact or seal newly filed records, expert witnesses. And that's it. That's it. That's what we have coming up. So none of that is like super exciting. So let's go back though, back and forth. Let's do, wait, we need to go down. Okay, here we go. This one. Twiz, why are you orange and not brown? Are you always brown? What's from today? Okay. So this is the latest one that we can open at this juncture. So order sealing defendants unredacted motion in limine number 5. The court having before it, I mean, this is not really, I can't read this chicken scratch. Can you guys? I can't read that. I see there that word says testimony. That's all I got. Who writes like this? Oh, you can pick the color? That's cool. I like the orange. The orange has the pop to it. The orange has the pop to it. So you think it's from today when they are unsealed? What do you mean? Because, the case summary doesn't show them unlocked. I would love to see that they are unsealed, obviously. But what I would expect, so here's what I would expect. What I would expect if he was unsealing these is what I would expect is for them to not be yellow and for them to be red instead. Even if they hadn't posted yet on the docket, I would expect them to be red here. By the way, did any of you guys see oh, I see what you're saying, Meg. From today's date, things come in. Okay, that makes sense. Freaking love cruise control. So, did any of you guys see the Court TV special that was like, oh, what was it called? It was just recently, and it was like about the alibi or something. I forget what it was called. Something related to an alibi. And or no. Sorry. The title was about something with autism, okay? Did you guys see that one? It was, Court TV, and it covered not just the autism, but like they also addressed like the alibi. And I actually think it might be worth watching together because there's a lot of interesting things to talk about. Like I have a lot of thoughts. And one thing I will say, so in other words, if you haven't seen it, I think we should watch it. So, and in fact, I didn't even have a chance to watch the whole thing. I was like, we need to watch this as a channel. But one thing I will say is that it becomes with every day, it becomes increasingly clear to me that even people who are attorneys or detectives or law enforcement or whatever that should probably know the difference on how the cell shit works, they don't understand. Like the number of times, and I'm just like dancing as I'm standing here dancing because I'm just like, it drives me crazy. The way that people just use these words interchangeably, right? Like GPS and cell towers. And I'm like, oh my God. Anyway, it's crazy. It's crazy because it's so important and it's so crucial in so many cases. And you would think that somehow it would have been clarified so that the general masses would understand the difference between these different methods and different ways that you get data, especially as it pertains to location. And like, and I'm not blaming anybody. It's just crazy. Like, in other words, I don't know who would be responsible for making sure everybody's on the same page about it. I don't know. I have no idea. I don't have a solution. I just think it's crazy that there isn't, someone else hasn't figured out a solution by now, if that makes any sense. Welcome Too Fast. Oh, thank you. Someone, so you can read that crappy handwriting. Well done. And before the documents contain grand jury testimony, was just exempt from disclosure. Okay, thank you. Amazing that you could read that. That's like a special talent right there. For sure. That's special talent. So, I think we need to watch that together as a channel. Gosh darn it. Okay. I'll have to set up a separate live stream for that though. Okay. So, but let's just, so now we've recapped what's going on with Brian Kohberger, because that stuff just happened. And now we're going to jump back over to why we are here, which is Karen Reed. I almost said Karen Kohberger. Oh my God. So many cases. So let me go back to, is this the one? No, hold on. Which tab am I sharing here? Not that one. I'm just trying to find the right thing. Where did it go? Oh, I think this is the right one. Okay, here we go. This is the right one. This is the right tab. Okay, there we go. So, let me just make sure I've got this. Okay, cool. There we go. Now we're all set. So, all right. 147 pages. All right. So this is what we're doing. And I've got Yuri pulled up and ready to go. Okay. My goat is ready. My goat has been rejuvenated, you guys. My goat has been rejuvenated. It's got its ear fixed. It's got its new battery. So we're in good shape with all that with the goat. So all right. Defendant Karen Reed's motion to dismiss for extraordinary governmental misconduct. Comes now. Now comes Karen Reed. Citing all of these different amendments to the Constitution, as one does, Massard Crimp, to dismiss all charges with prejudice on the basis of extraordinary governmental misconduct. A prosecutor, oh boy, I love this already. Quote, that's what she says potentially coming up, guys. A prosecutor, quote, may strike hard blows, like blunt force trauma, but he is not at liberty to strike foul ones. It is as much his duty to refrain from improper methods calculated to produce a wrongful conviction as it is to use every legitimate means to bring about a just one. Oh, question about some chocolate here. Is there not an expiration date? I know exactly what you mean. By the way, I'm a huge chocolate fan. Freaking love chocolate. Love chocolate. The white powder, that does mean usually that it's old, but it may not be harmful. It just might be not as tasty. So I would imagine there's an expiration date though, right? Now, what I will say is this. Sometimes what happens is if you go to eat it, when it has that whitish powdery look on it, if you can tell because it tastes off, right? But if it tastes okay, it's probably okay. I mean, what I would do if there's no expiration date, what I would do is I would take a bite of it, and then if it's like right, then you can spit it out. Words of advice from a squirrel. Words of squirrel advice. So squirrel wisdom. So it's not mold. It wouldn't be mold. It's not mold. It's just like, I think it just dries out or something. It's not mold. I don't think chocolate molds. Oh, wow. Yeah, that's a good one too. That's the good shit. Ghirardelli, dark chocolate, sea salt caramel. There's got to be expiration date on that. Was it in a wait, hold on. Let me just make sure. Was it's in a tin. Was it sealed? Like, is it sealed or was it opened packaging? Oh. Dark chocolate is just not as sweet, but since this one has caramel, it should still, I'm sure it's still going to be kind of sweet, like overall. Like, it sounds really tasty. Like, don't eat moldy food, people, but I don't think chocolate molds. This is the most important thing right now. We have to solve this. The tin says Merry Christmas on it, has 2 kinds of chocolates in it. Okay. So we're trying to figure out, is it from this Christmas or last Christmas? There's got to be an expiration date. Look at the bottom of the tin. Look under the lid. Or it could be that there's like the 2 different chocolate. Maybe there's individual expiration dates on what's inside the tin. Like what's inside the tin, is it wrapped inside the tin? Can we get pictures? Maybe pictures in the Discord. We can solve this. Like, because I'm trying to picture this and I figure that there's probably a tin and then the chocolate itself is probably also wrapped in plastic. So there could be expiration date on that. Blue cheese. I don't know where Heather is. Cuckoo, cuckoo, calling all squirrels. Cuckoo. That's the squirrel call for Heather. If you want to post pictures in the Discord, we can probably help you more so. Okay. So throughout the course of these proceedings, Miss Reed has been severely prejudiced by the Commonwealth's pervasive misconduct. I would agree. The Commonwealth has suppressed discoverable and exculpatory video surveillance footage. Lallyport from the Canton Police Department has provided piecemeal disclosure of some footage, most of which was disclosed after the trial started and after the Commonwealth represented that, quote, in scare quotes, all video footage had been provided to the defense. For reasons that remain unexplained, much of that video has been disclosed much of the video that has been disclosed is missing critical timeframes and evidence central to Miss Reed's defense. Some of the video clearly appears altered or manipulated as evidenced by people appearing and disappearing out of nowhere. All of the ghosts. That shit's insane. And we're going to watch some of that as well. People appearing and disappearing out of nowhere. At the first trial in this matter, ADA Lally brazenly introduced, quote, inverted, end quote, video and elicited patently false testimony from MSP Sergeant Yuri Bukhenik. That the video was a fair and accurate depiction of critical events in an attempt to falsely insinuate to the jury that no member of law enforcement ever approached, touched, or otherwise disturbed the right rear tail light of Miss Reed's SUV. There could be no doubt that this video and false testimony was offered to mislead this court, the jury, and the defense by making it appear that MSP Trooper Michael Proctor was standing next to the left rear tail light when the Commonwealth knew the exact opposite was true. Trooper Proctor was in fact standing directly next to the right rear tail light. Other Lallyport video, which was unquestionably favorable to the defense because it would have severely discredited key witness Brian Higgins, inexplicably was not disclosed to the defense until months after the first trial. To this day, the Commonwealth's failure to explain the disturbing circumstances surrounding their disclosure of the exculpatory Lallyport video and why some video was suppressed from the defense at the first trial has made a mockery of Miss Reed's right to due process. Couple things. I don't know how more people haven't started calling it the Lallyport. Big shout out to DSN for that because it was his idea and it's a no-brainer, right? I don't know why. I've never heard anyone else. I mean, other like YouTube channels or anybody, right? It's like they call it the Sallyport. Like my brain is the first time that DSN said Lallyport, I was like, done. So I actually have to reroute. Like if I hear somebody say Sallyport, I'm actually like, oh, they mean the Lallyport because I don't even like, I'm like, what's the Sallyport? So anyway, just saying, oh, that's interesting. So did somebody, the tin isn't what well, it could be from 2020, couldn't it? Okay, I'll do the Heather call again. Also, we have a thing. Here, let me just do the thing. We have an actual video for it. Hold on. Where is it? Here we go. Cuckoo! 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 Calling all squirrels. Cuckoo! that's the official squirrel call. People have joked that if and when I ever become a defense attorney, then they're ever in trouble and they are, you know, being detained or whatever, that under their breath, they'll be like doing the squirrel call. And then I just appear out of nowhere, like, you know, here I am, you know? So I'm just, this is a real mystery with this chocolate here. And I really want to solve this. So it says Christmas 2020. What makes you think though, that the chocolate in the tin is not from 2020? That's the real question, because I would think that maybe it's from 2020. I mean, you know, it tasted non-desirable, then don't eat it. Yes. So how do we spell it? So I think we usually spell it like, let's see, like I've typed it out before. Kiku, something like this. Cuckoo. Anything along those. Yeah, it's a, you know what? They're all great. That's all good. Yep. That all works. Cuckoo. Calling all squirrels. So if it tasted non-desirable, I wouldn't eat it. Maybe it's from 2020. Could be the thing. Dark chocolate is really amazing. And I love chocolate. Now I want chocolate. I love the orange. The orange and the green just has a nice pop to it for Twiz there. So, okay. So now, hold on. Oh, the snow, it melts the soonest. Okay, so it is time to rewatch some of this. In lieu of all of this. And the other thing I will say is this. A lot of people, it's come up on this channel, and I'm sure other channels, we've all been wondering what the fuck happened with the like the Ring doorbell for, like, remember that whole thing, guys? Kind of got swept under the rug or went by the wayside. You know, pick any of your colloquialisms there. You know, with the John O'Keefe's, like, the Ring doorbell, right? It was like, what the hell happened with that? There were so many things. Okay, there were so many things in this trial that were like problematic, that were like things were just missing or disappeared or whatever, that I think it was easy to forget them all. And as I was going through and trying to find the parts of this testimony that are pertaining to what we're talking about here, you know, I was reminded of all of that. So we're going to get to this. We're going to watch just a little bit of this as it pertains to the shit related to the videos. And I'm sure we will hear about snow in the mix as well. So let's see if this is the right place.
All right, Mr. Lally, whenever you're ready.
Thank you. Good morning, sir.
Good morning, sir.
I've got Lally on 1.5. Let me know if it's too fast for you guys. That was a pun, kind of like, is it too fast for Fleas? Was it too fast for you guys?
Circle back just to a couple things from your testimony from yesterday. Going back to the video that you reviewed for both C.F. McCarthy's and Waterfall. In total, from those two videos, how many drinks did you observe the defendant consuming over her time?
The video shows 9 drinks being consumed by the defendant.
And that's between when she arrives at C.F. McCarthy's until the time that she leaves the Waterfall. Is that correct?
That is correct.
If I could turn your attention to the Ring videos from 1 Meadows Avenue, Mr. O'Keefe's residence.
Ah, the Ring videos, you don't say.
From the videos that you observed, let me ask you first, as far as, do you know how those cameras work as far as when they turn on and when they turn off?
Yeah.
My understanding is that Ring surveillance video is triggered to be recorded through motion. So if the camera detects motion, which is constantly live monitoring, and motion is detected, then that video is captured to a cloud-based system.
I just have so many thoughts. So the thing about the motion, right? Because the Lallyport and the motion activated, and oh God, it's just, oh my God, I have to try to reserve the goat for the worst of it.
Is that Ring surveillance video is triggered to be recorded through motion. So if the camera detects motion, which is constantly live monitoring, and motion is detected, then that video is captured to a cloud-based system that retains that footage.
And from your review of those videos, what kind of motion would set those off? Like, what kind of things would be recorded from the driveway camera?
Be activity in the driveway, such as a person walking through, bird landing, a vehicle pulling in, individuals, moving around in the driveway, and so forth.
A bird landing. Okay. So, you know, just thinking about that from when they say, the Commonwealth tries to say that the motion activated Lallyport cameras didn't trigger when the Lexus SUV drove by there. and that didn't trigger it. And we just heard bird landing. You know, I will say this as well. I was actually just telling Twiz about this. So my neighbor, so the room that I'm standing in right now is the room that I teach all my lessons in. This is where I have all my instruments, where my orchids are, and it's where I do all my live streaming. Basically, it's the room where I'm at all day, every day, pretty much, right? Like this is the room where I'm always in. And so this has windows that overlook the backyard. And the backyard, my backyard, my neighbor's backyard, there's no fence, like they're kind of all one big backyard. And there's like the woodsy area behind, as you guys have heard, it's like a magical forest over here. I've got all kinds of animals. But I just wanted to point out that as far as motion detection goes, so my neighbor is real big on like security and has like cameras and shit everywhere, and motion activated cameras and motion activated lights. And he's got a garage that's like separate from the house. The garage is like in the backyard, and it has like motion activated floodlights. And these floodlights are like the type that would light up a fucking football stadium. Okay. Like this dude spares no expense on this type of stuff. It's pretty crazy. So in other words, like it's pitch dark. Like if like looking out my backyard right now, it's pitch dark. You can't even see any lights from like traffic or, you know, like honestly, it's like, wow, how's it so dark out there? Like there's no lights, you know, like usually there's just like street, like there's just no lights. There's nothing. But if at night, even if there's just like a bird or a chipmunk or a squirrel, if there's any animal at all, bam, that motion sensor triggers, and it not only turns on his camera he's got there, but it illuminates these floodlights, and it lights up the entire fucking backyard as if it's broad daylight. And so that's why sometimes when I'm live streaming, I'll be like, oh my God, a raccoon or whatever, because literally you can't miss it, right? Because like, it's like, I'm standing here, I'm looking out the window, it's pitch dark, can't see it. And then as soon as that light comes on, that's how I know, oh, there's an animal, you know, a raccoon, a fox, a deer, whatever it is. So anyway, the point being that it strains credulity that these Lallyport cameras have so many issues when, you know, Ring doorbells and other camera type things that are available to just civilians, right, have that high level of sensitivity and can adequately activate when there's motion, which is their job. That's their one job. Their one job is to activate when there's motion. So welcome back, Kimmy. Well, happy to see you. I say, yeah, Lallyport. It's Lallyport. That's what it is. It is the Lallyport. It's Lallyport. Yep. That's what it is. Lallyport. Obviously. I don't know why that has like, how did no one else figure that out? So, so it just blows my mind. It just blows my mind about that. But yeah.
The search warrant that was applied for was any and all videos between January 24th and January 3rd, correct?
For one of the search warrants, that's correct, yes.
And with respect to that time frame, what, if any, activity based on information that you had received was not available or was not shown on those Ring videos?
The data returned had video that would have been captured from the defendant arriving home after midnight on the 29th, after she dropped Mr. O'Keefe off at 34 Fairview Road. That video was not present in the data that was returned from Ring.
What, if any, other video in addition to that one was not present?
There was also video missing from the defendant showing Ms. McCabe and Ms. Roberts the damage to her right rear taillight.
And what, if any, follow-up, or what, if any, inquiry was then done with regard to Ring as far as...
Imagine that. Hold on, guys. The thing is this, right? Here's the thing. As it pertains to the Lallyport videos, it's like, oh, the things that happen to be missing are the things that are crucial. Like, what did the car look like when it was pulled into the Lallyport, right? Like shit like that, right? The shit that is crucial in establishing this important fact in this case, that's what's missing. But you know what? It's not just with that. It's with the Ring videos. Look at what's missing.
The defendant arriving home after midnight on the 29th, after she dropped Mr. O'Keefe off at 34 Fairview Road. That video was not present in the data that was returned from Ring.
What, if any, other video in addition to that one was not present?
There was also video missing from the defendant showing Ms. McCabe and Ms. Roberts the damage to her right rear taillight.
And what, if any, follow-up, or what, if any, inquiry was then done with regard to Ring as far as...
the thing is this.
Those types of videos or...
I'm trying to get more creative so I don't just yell, you know, explicit curse words at this shit. And so instead what I'm going to do is this. I'm going to quote my grandmother who was born in Wales, came to the U.S. when she was 21, I She passed away at like 99 years old. And here's what she would say to this. Here's what she would have said to this. She would have said, "Do you think I was born yesterday?" That's what she would have said. So I'm going to try to get creative, and I'm going to use other sayings in addition to cursing and goading. And to this, with all this, you know, the fact that this is what's missing, right? Like to Lally and to Trooper Bukhenik here, it's like, do you think I was born yesterday, right? And why has there not been more follow-up on this, the Ring stuff?
Deletion or how those videos could not be present.
Correspondence with Ring produced information that
Sustain.
Let me ask this first. Was there follow-up with Ring in regards to those videos?
yes, there was.
And was there ever anything produced with regards to those videos or those timeframes from Ring?
No, there was not.
If I could turn your attention over to your time in Dayton, just in reference to subsequent to that later on, what, if anything, did you receive, or what, if anything, did you request, what, if anything, did you receive from the Dayton Police in regard to January 29, 2022?
I communicated with the Dayton Police Department requesting documentation from their officers' calls for service at our request, and log notes, logs from their dispatching center, as well as any reports that would document their activity if such reports existed.
And did you, what, if any, information did you receive in relation to that?
I received a log note or log printout from their CAD system, and I received a report authored by Officer Barrows.
And did you also receive any 911 calls?
Yes,
And who was the party as far as the 911 caller in regard to those 911 calls that you received?
it was Mr. Reed.
And again, just for clarity purposes, that's the defendant's father, is that correct?
That is correct.
And that's on the morning of January 29th, is that also correct?
Correct.
Now, sir, if I could turn your attention to February 3rd, 2022. At some point that morning, where did you go?
During the morning hours of February 3rd, we planned to meet at 34 Fairview Road. Myself, Trooper Proctor, and Trooper DeChico arrived at that location in order to conduct a secondary search of the area as the temperatures were turning and the snow was melting.
There it is.
Naturally. We decided to...
This is when I started, again, earlier tonight when I was getting this shit ready, and I was like finding this part of the trial, and I heard this, and this is when I just started singing because I'm like, this trial is so insane. The fact that he says the snow was melting and then he has to clarify naturally, as opposed to what? You didn't take a hairdryer to it? It's just, you know, like what? Why are we...
arrived at that location in order to conduct a secondary search of the area as the temperatures were turning and the snow was melting naturally. We decided to do another search for articles that were now, we realized and learned, were missing and could be of evidentiary value and aid in the, in the investigation.
And with respect to going to 34 Fairview Road, what, if any, tools or what, if anything, did you bring with you, you and the other troopers, in regard to conducting that secondary search?
Leaf blower, hairdryer, flat iron.
I requested the troopers bring shovels, rakes, anything like gardening items that would help them to dig through the snow and locate any missing items.
And as far as the temperature change that you're talking about, how precipitous a change are we talking about?
The temperatures went above freezing, so the snow did begin to melt, and it was significantly warmer compared to the 18 degrees.
Yeah, what we're gonna do, guys, in this next trial is we're gonna have counters for things. And I don't know that we're gonna hear much about the apron, right? And we probably won't hear as much about the high tops and as much about the snow. However, I'm sure we will still hear shit about the snow melting and whatever. And we're gonna have to do, make a counter, an ongoing counter for that. Yeah.
The night of the incident.
Now, you mentioned items of evidentiary value that you had learned of and were looking for. What, if any, clothing items, Mr. O'Keefe, were you looking for specifically on February 3rd?
We were specifically looking for Mr. O'Keefe's baseball cap.
I'm going to go ahead a little bit.
Notified who, if anyone,
Shoe State Police were, I believe.
or was it generally speaking?
So what we're looking for the shit as it pertains to the videos. So there's the plastic. I think these are the photographs of the yard. Lally takes forever. Okay, there's the yard. And I'm wondering, okay, let's see where this is.
Ms. Gilman, if I could have photograph 7700. Photographs?
Yes, I do.
And what do you recognize those photographs to contain?
They contain small red pieces of plastic from 34 Fairview Road on the grass.
He still goes
Collected the item that presented itself.
And if you recall, that item that you collected on February 4th, was that located on the lawn, on the street, or something else?
It was on the lawn.
Okay, so here's
Now, reference to your collection of these items either on February 3rd, February 4th.
so here's where he opens all this evidence, and then they play that recorded part. Let me go here. And then there's cross. So
clear. I'm talking about the specific ring video or series of videos
okay, great.
that were associated with One Meadows.
Perfect.
Okay.
Okay. You didn't write the search warrant for those ring videos, did you?
I did not.
You were not the affiant for those search warrants.
I was not.
Who was the author of the search warrant and the affiant?
It was Trooper Mike Proctor.
Who received the actual ring video or videos from?
So again, this is crucial with these ring videos. So Kimmy, were you sick? You took a COVID test? Interesting. I had COVID once. I didn't get COVID. Well, here's the thing. I didn't get COVID for the first time since the entire pandemic started. I didn't get COVID for the first time until January of last year. 2024. January, wait. No, hold on. Yes. January of 2024. It was during the same time as like the Michelle Draconis trial. And I was really I was hella COVID-y. I was really sick. Like, it's really funny. It's like all those years I never got it. It's as if it kind of like, by the time I got it, it was like, okay, well now you're making up for it. Cause like my COVID test thing was like off the charts for like the antibodies or whatever it is. Anyway. But I'm glad you're feeling a little bit better, sounds like. I hope you get well soon. And we have a command for that as well, by the way.
For those ring videos, did you?
I did not.
You were not the affiant for those search warrants.
I was not.
Who was the author of the search warrant and the
All right.
affiant?
I'm an idiot. Let me do this correctly. I forgot I have to put, hold on. And I'm just going to use Kimmy because that's what we call you here. There we go. Twiz says he's never taken a COVID test. That's insane. Interesting. Yeah. Because I mean, it's possible that you can get a false negative. But yeah, when I tested positive, the test was so crazy that I thought it was a mistake. I thought it was a malfunction because I was like, wait, what? Because it wasn't supposed to have it wasn't supposed to be positive that quickly, and the color was like darker than the example. Basically, it was like what? Like in other words, the line for positive appeared before even the control line did. It was insane. It was like immediate, and I was like, oh, okay, this must be malfunctioning, must be old. I was so convinced that couldn't be possibly that couldn't be possible that I took like 6 tests or something like in a row with like different brands because I was like, oh, because they're not all malfunctioning. Basically, it's like if it's off the charts, then that can happen. But yeah, it's okay. We love side quests here. It's totally fine. People always apologize, and I don't know. It's all good. And you know what? Whenever we take little tangents, I always put them in the timestamps as well. So when people on Replay Crew want to skip them, they can. So yes, zinc. Zinc is always helpful. Vitamin C. Yep. Ginger, turmeric, also good. Yep. That's always good as well. Yeah.
Sergeant Bukhenik, I'm going to start with one of the latter things that you discussed with Mr. Lally, and that's specific to the ring video that y'all talked about this morning. Do you have that in mind?
I do.
The search warrant that produced, and just so we're clear, I'm talking about the specific ring video or series of videos that were associated with One Meadows, John O'Keefe's home.
Okay.
Okay. You didn't write the search warrant for those ring videos, did you?
I did not.
You were not the affiant for those search warrants.
I was not.
Who was the author of the search warrant and the affiant?
It was Trooper Mike Proctor.
Who received the actual ring video or videos from the Ring Corporation?
It was Trooper Mike Proctor received it.
And who ultimately either logged those into evidence or controlled those once they were received from the Ring Corporation?
I believe it was Trooper Mike Proctor.
And ultimately, Sergeant Bukhenik, you did note that in addition to just the physical videos themselves, that login information and login keystrokes, et cetera, were requested from the Ring Corporation as well, correct?
There was discussion with Ring asking for those logs.
I'll call it, is it correct to say an activity log?
That's what was requested as activity log, yes.
So ultimately, the activity log would show who logs in, who accesses the data, things of that nature, correct? Or at least that was the hope.
That is what was requested.
All right. It would also show logging in and executing deletions, manipulating the log files, things of that nature, correct?
That is what was requested, yes.
When you reviewed those log or activity logs, there was no evidence revealed that my client ever logged into that account, correct?
There was no activity log provided by Ring.
So you have zero, hang on. Isn't it true that Ring contacted Trooper Proctor and indicated that they had created a Dropbox folder that contained the evidence that had been sought in the search warrant?
Objection.
Sustained.
Isn't it true that the search warrant return specified account information, video recordings, and number 3, activity logs associated with video recordings for all times displayed in UTC?
I'm not aware of that, no.
Do you recall that activity logs were in fact provided from the Ring Corporation?
I do not recall that, no.
Okay. May I approach briefly?
Yes.
Take a look, Sergeant, at that paragraph with my fingers on it, the third paragraph down the middle of the page, and review that to yourself and let me know when you're finished.
You know what? It's so funny. I remember now he takes forever on this. I remember this. I was covering this live. I remember this really well. It's a long time. I've got it on 1.5 speed. It's a long ass time.
Saw that document, so it does not refresh my recollection. I simply read it.
So do you have a recollection, as you see here, that in fact, during the course of your investigation, the 3 items that you received from the Ring Corporation were the account information, the video recordings, and, quote, activity logs associated with
Twiz wants to see the pictures of my tests. I can put them in the Discord. That might be the best way to do it because they're on my phone. Yeah, I'll show. Well, and I don't know if that would mean anything to you. If you've never taken a COVID test, I don't know that you would if you haven't taken it, well, you're probably the only one who hasn't taken one, but it would be harder to appreciate why it's so crazy. But for anyone who's taken a test, you will appreciate why it's crazy. By the way, that is how you would actually spell Yuri's name in Cyrillic. That is the correct typing. That is the correct spelling. That is it right there. That's Yuri Bukhenik in Cyrillic. So I just thought I'd put that in the chat because, you know, I know everybody likes to butcher his last name because it's funny, but, you know, I actually appreciate that it's an opportunity to use my Russian skills. So I have no idea. I've never heard of that. Quercetin? Never heard of that.
the video recordings, all times displayed in UTC.
To the extent of its availability, as it says in that document.
Okay. The long and short of it is, during the entire course of your investigation, you never revealed that investigation never revealed any evidence whatsoever that my client ever even accessed the account information for the Ring account associated with the search warrant, correct?
Nothing provided by Ring proved or suggested or proved any evidence of that type of activity, no.
Trooper Proctor, you were notified.
I'm not Trooper Proctor.
I'm sorry. No, you're not. Sergeant Bukhenik.
Sergeant Bukhenik.
How do I say it?
Bukhenik.
I'll give that a shot.
It's fine.
Bukhenik?
Yes.
Is that better?
That's better. Thank you.
Okay, so here, hold on. Oh, that's funny. Timely.
No, you're not. Sergeant Bukhenik.
Sergeant Bukhenik.
How do I say it?
Bukhenik.
I'll give that.
Okay. So looking at the last name here on the screen, right? So I know that y'all are going to look at this and be like, what the fuck am I looking at? So that first symbol in the second name, you guys can, I'm sure, see it's two words, right? So that looks like a B. It actually is pronounced like a B. That's not always the case in Russian, right? Or Cyrillic. So there's the B. So then the Y, what looks like a Y to us, right? That makes a oo sound. Okay. Now it looks like an X, the third letter, that makes a ha, ha. It's like a KH type almost. So like, ha, ha. So it's got that throaty thing going on. That's what she said. And so It's like a KH. That's the best way to describe it. And then the E, what looks like an E to us, that is a eh. And then what looks like an H to us, that is an N sound, N. And then what looks like a backwards N, that is an E sound, kind of like E. Yeah, this is what we're talking about. This alphabet is insane. I love it so very much. So what looks like a backwards N, that makes like an E sound. And then the K is a K. So again, so this is not one of the this is one of the easier words, I would say. Like if you look at the first word, right? That symbol that we have nothing that looks like that in the whatever, what do we call it? The Roman, what is our alphabet called? I don't even remember. The Roman something, whatever. Anyway, the one we use in America, we don't have a comparable or comparable symbol. So that is a U sound. So it's like Y-O-O, U. What looks like a P, that makes an R sound. So we've got, so far in the first, we've got Yuri, right? Y-O-O-R, like if you're thinking of it phonetically. And then again, the backwards looking N, that makes an E sound. And then there's another one with a little symbol on top. That's what they call Ikratski. That, well, okay. It just basically, in terms of gender, if it's masculine, it's going to have one of those at the end. Because you can't have a word ending with just one of those E's. Never mind. That's too complicated. We'll just skip that. Don't worry about that part. Basically, it's just another of the same. So you get Yuri, okay? And then, yeah, and then the B, and then the U, and then the H, and then the E, and then the N, and then the E, and then the K. So there you go. Now you guys know. The Cyrillic alphabet is really cool, though. I freaking love it.
Yeah, that's fine.
Bukhenik?
Yes.
Is that better?
That's better. Thank you.
If I screwed up again, please. On January 29th, you were notified about a Boston police officer found gravely injured outside the home of 34 Fairview at about 6:40 in the morning. Was that your testimony?
That is not.
What time were you notified?
I was not notified it was a Boston police officer.
So you didn't have that information upon the first notification?
I did not.
Okay, what information did you have?
There was a male party in the snowbank, possibly of a heart attack.
At what point did you learn that the individual was, in fact, a sworn Boston?
So now we're going to go ahead a little bit here to the Lallyport. Cocktail glass. Good Samaritan Hospital. Oh man, and why they didn't go search the house. I mean, there's just so many things. So many things. Okay. The butcher paper. This is not a vision contest. Huh.
I'll bring these up to you in just a second, but just for familiarity's sake, do you recognize these two bags as bags that you brought to court with you yesterday?
They look familiar, yes.
Okay. This one has a 437 on it on my right. The one on my left is were bagged after the clothing was dried. It indicates that Trooper Proctor is the one that...
20.
Correct.
It says number 437?
Yes.
With
7 has the gray sweatshirt in it. 438 has the orange. This
the reason
looking tag, a white tag that's on that bag indicates that it was...
Heather's here.
Indicates
Heather's
a date.
here. Okay, I'm just going to go forward a little bit. Heather's here. Yay. The scroll call worked. It was just a little bit delayed. We've had a lot of fun discussions tonight. We've talked about COVID tests, chocolate. Hopefully, Too Fast, are you still with us, or did the chocolate do you in? You know, we did a little bit of a Russian lesson.
date indicates February 4th, 2022.
Right, and that date would be indicative
We
in
did
your...
some updates on BK.
True log of those items is when we collected them from the hospital.
I want to talk a little bit half year and several months later, correct?
If you say so, I do not know the exact date. That report would have to be presented to me.
This might be
May I approach?
Yes.
Lallyport. COVID and chocolate, right? That's right.
You don't have to read the whole thing, but if you can skip to the part that talks about the February 4th and February 10th searches.
I love whenever it says music on the things. There's no music.
Additional question. Does that refresh your recollection as to the date of the report that actually talks about the video report? And video returns?
It does.
With the sound
Now-
of not music.
As it relates to those two searches, I'd like to add 234 fair.
I personally responded, yes.
Okay. That was because you had
Okay,
received
we're talking about searches, so we're going to go ahead. We're getting to the Lallyport. 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 What song is that? I mean, not that the song has Lallyport. Oh, Lollipop is the regular version. Okay, now we're getting closer, I think.
That was my understanding.
Isn't it true that you knew that the entirety of the Canton Police Department had recused
Yeah.
itself because
Me too.
of familiarity between one of their members, Kevin Albert, and the Albert family?
And the applause is appropriate, right? It's like the closed caption thinks there's a classical music concert going on, right? Or it's like music and then applause. It's freaking hilarious.
Lawn, John O'Keefe was found. That was the conflict, right?
I knew that was the connection between them, yes.
And you understood, sir, that to the prosecution PD,
Yeah.
Canton PD was after
It's not there yet. No, Lallyport. Glass, hat. Red and clear plastic. Oh, right. I remember that moment.
a red, black, and clear glass, correct?
That's correct.
But that is not an evidence bag that was filled out by you.
I did not fill that bag out, no.
Matter of fact, that's Trooper Proctor's handwriting,
I do not know
Yes,
what Trooper
please.
Proctor's handwriting is. I cannot confirm that that's his handwriting.
but it's not your handwriting.
It is not my handwriting, no.
So are you aware that this particular bag, that bag, that contained those 6 items?
Yeah, I don't know. What are you referencing here, Twiz? You can always control F yourself. I do it all the time in transcripts.
Material that you already deemed was incredibly important to the investigation was never brought into any evidence until March 14th, the date that was submitted to the crime lab.
I was not aware of that, no.
No,
Let me take that down. Space.
Lallyport.
If I may approach, Your Honor?
Yes.
Given the recovery of those 6 items, and that, is
Who collected it, when, where?
that right?
Okay.
Shift gears for just that bag. And if the bag is presented to the crime lab on on March 14th at the crime lab. Gears to 5.
I do.
Okay. You indicated yesterday on questioning,
Oh.
under questioning by Mr. Lally that Miss Reed's car came in contact with or close to coming in contact with the other vehicle, the Traverse in the
This
video.
part is good as well here.
Is that right?
The video, as I watched the video, I observed the vehicle come near Mr. O'Keefe's car.
Okay, that's what I want to talk about. With the court permission, maybe play that video one more time. Basically, pull that up and then ask you to pause it.
Yeah, so I don't know. So I'm going to, I mean, a lot of this is worth watching again, but I'm going to go ahead. I'm trying to get to the Lallyport. Okay.
For the end of the day yesterday. Did you actually,
Ah,
I want to talk about the one that is the clearer of the two, where you slip. You remember that one?
If you pull it up, I can.
I will in just a second.
Okay.
There was one where Mr. Lally paused it and you were slipping in front of the vehicle.
I don't recall myself slipping, no, but it was icy that day. So if there's documentation of me slipping,
Fair enough. I didn't mean anything by that other than that was a moment that I thought you might recall to differentiate the videos. It's Exhibit 446,
he's like, I wasn't trying to call you clumsy. Oh,
but I
dear.
don't think that's going to help you. All right, let's see if I can do this another way. Did you actually personally go to Canton PD to retrieve any or all of the videos of the Southport? You yourself?
Here we go.
I did go to Canton and collect already extracted video,
Okay.
but it was a portion of video surveillance.
Here we go. I'm going to slow it down a little bit. I wish if I were a genius with computers and I could computer hack things or whatever, the first thing I would do is I'd figure out a way, if it's possible, to get into the closed captioning for this trial, for any hearings or the upcoming trial, and to make sure that every time that it would say Sallyport, it needs to be swapped with Lallyport on the screen. It just needs to be done.
I didn't collect all of the video, so
When was the most recent time that you went to Canton to collect portions?
Okay.
I don't remember.
Okay.
I don't remember. I'm sorry.
Did you review let me ask it this way. Did you collect the video that was sought on or about April 23rd or 24th this year? Maybe just a few weeks ago.
Did I collect it?
Correct.
I did not collect that video of April this year. No.
Or you're aware that the video that you saw yesterday was
Okay.
in fact collected after the trial started in April of 2024?
Objection.
Sustained.
Are you aware of when that video that we saw yesterday was collected?
Objection.
Oh,
I am not aware.
Okay. Was yesterday the first time you'd seen that video?
No,
When had you seen that
Oh my
video
God.
previously?
a couple of weeks ago.
Okay.
Oh my
What
God.
were the circumstances
God.
in which you saw that video?
Objection.
sustained.
Did you have a meeting with?
Notice how he looked over at Lally. It's funny because Lally doesn't, Lally's just a bump on a log. He's just like, the Idaho, or like, he's just like a bump on, and he's like a potato. That's why I'm like, I'm thinking Idaho, because he's like a potato. He's like a potato, but he's Lally. So, well, notice how Yuri looks over at him and he objects. And it's not the only time. We've seen this with other witnesses. Like what was my point? My point is Lally's useless. But one thing that he does is there's many of these witnesses in this first trial. And I mean, I don't know that we'll see it again with Mr. Brennan, but where clearly they've made an agreement where like they look over and he objects. With McCabe, it happened a ton. And there was a handful of times where she looked over at him and he couldn't object, but it's like on cue, right? So I just wanted to point that out. But also I just wanted to say, it's a nice looking suit he's got. I mean, there's not much we can say nice about him, but I think he's got a nice, suit thing.
Okay. Was yesterday the first time you'd seen that video?
No,
When had you seen that video previously?
a couple of weeks ago.
Okay. What were the circumstances in which you saw that video?
Objection.
Sustained.
See there?
Did you have a meeting with the DA?
Objection.
Sustained.
Did you ever have any kind of communication with Mr. Lally about your testimony?
Objection.
Sustained.
May we approach?
Yes.
It's like, so you guys see what I mean though? It's like Lally's like completely fucking useless, except that he's objecting in these moments where shit would get these witnesses, on the stand. It would not be good for the Commonwealth, right? So
In anticipation of your testimony?
Yes,
When was that?
it was about 2 weeks ago, and then last week, I believe.
And what was discussed? Generally.
Generally, we discussed the portions of the case that I would be presenting.
Did you write a report about your communications with Mr. Lally?
No, I did not.
Were you shown any of the videos that you've seen here in anticipation of your testimony?
Not during the first meeting. I did review a video during the second time.
Okay, and that video was that you did see the second time was the interior video of the Lallyport that we saw
Lallyport.
yesterday, correct?
I'm just trying to remember exactly what video I saw. I had
Wow.
reviewed videos outside of.
So this is really fucking important, right? Because I'm going to back it up. This is really important because it's still unclear, right? Obviously, what the fuck is going on, right? And his answers, right? It's like are so wishy-washy and weaselly as to when and how and under what circumstances. So let's just listen again. Wow.
Not during the first meeting. I did review a video during the second time.
Okay, and that video was that you did see the second time was the interior video of the Lallyport that we saw yesterday, correct?
I'm just trying to remember exactly what video I saw. I had reviewed videos outside of our meeting, so I don't remember exactly what video Mr. Lally showed me.
But you do recall seeing the video that you saw yesterday, the sort of clear one that has the crime scene tape being put up and all that. You have seen that one before,
Yes,
and that was with Mr. Lally, correct?
that is not correct because I do not recall when I saw that video or what video I saw with Mr. Lally.
I see. All right. I'd like to talk about that exhibit 446 for a second, and then I'll show it to you. You indicated that the video all the videos, everything that you saw yesterday is true and accurate, correct? Based on your memory of the events that were memorialized in the video?
The video captures events taking place
Here we
in
go.
an accurate fashion, yes.
In an accurate fashion. All right, that's what I wanted to find out.
Oh dear.
And after you watched the video, I think you were asked by Mr. Lally, does the video show you or Trooper Proctor having access to or messing with in any way that right rear tail light
Oh my
in any
God.
fashion? And you said never.
I was asked if at any point Trooper Proctor and I had came into contact, I believe, and or touched the vehicle and that portion of the vehicle, and I said never. We never touched the vehicle prior to it being properly processed with a search warrant.
And that was specifically his question was to, and your answer was to the right rear portion.
Right there.
Right, that right rear tail light.
The right rear damaged taillight, correct.
And that's why I pulled this up when I did, because we literally just read this part in the motion that cites this exact moment in this trial. This is what matters. This is what matters. Like, this is so fucking crucial. This is why the whole thing about being inverted doesn't just matter because of the fuckery. It doesn't just matter because what the fuck did they do to it? Like, in other words, is this forensically sound? Obviously not, all that. But even more importantly, it completely changes their positioning as it pertains to where they're located near the car, which is crucial for the defense theory of the case.
Trooper Proctor and I had came into contact, I believe, and or
Correct.
touched the vehicle and that portion of the vehicle, and I said never. We never touched the vehicle prior to it being properly processed with a search warrant.
And that was specifically his question was to, and your answer was to the right rear portion. Right, that right rear tail light.
The right rear damaged taillight, correct.
With the court's permission, I'd like to play a portion of Exhibit 446.
Okay.
All right, we're going to watch this on normal speed.
Before we begin playing it, Mr. Bates, if you wouldn't mind, may I inquire, Your Honor, of the witness, just to lay a foundation? Sergeant, do you recognize this as being the video that we saw yesterday?
It does look accurate.
Okay.
Yes.
I just wanted to make sure we're on the same
Crazy.
page. This is 446.
Crazy.
So you have it in mind if I reference that. Space, if you could play that. And I think it's runtime 120. Pause it. Do you recognize that as the video we saw yesterday?
Yes, I do.
Very briefly, if you could move to time of day, 5:37:05.
Again, I have it on normal speed. This is them zooming through to find the right spot there. They're doing all their freaking snow.
Yes. With the court's permission, can we play at this point?
Yes.
All right, that shows the vehicle coming into the Lallyport, and we're looking at which side of the vehicle.
So that is the driver's side of the vehicle. What that video depicts is a mirror collection. Although mirrors are accurate
I know.
representation of what you're seeing, it's just inverted. So that is the driver's side of the vehicle. I do not know why it is inverted, but
Yeah.
that's the way it was presented, collected and presented from Canton Police.
Can you see a timestamp or a time and date stamp on the bottom of that? It's in blue.
I cannot know.
Does it appear that time and date stamp?
I'm just going to ask another question here too, because if it's inverted, does it also mean it's facing the wrong direction? Like, I'm trying to remember. I'm sure it was covered, but like, in other words, he's saying this is the driver's side. It would almost be weirder if it's facing the right direction, but just flipped. Like, it would almost be like if they inverted it, should it have been actually facing the other way in real life? I don't know. This is crazy. And this is crazy. I mean,
Driver's side of the vehicle. What that video depicts is a mirror collection. Although mirrors are accurate representation of what you're seeing, it's just inverted. So
maybe
that is the driver's side of the
that's a good
vehicle.
point. Maybe there is a difference between mirrored and inverted. I don't know. Maybe that would be kind of the answer to my question about like, was it supposed to be facing the other direction, or is it just like it wasn't supposed to be? Like, I don't really know. There's no way it happened by accident. No way. Especially because the timestamp is not inverted. Yeah, there's another thing. There's like a number 4 that you can see at some point. That's also, you can tell. Right. I know. It's crazy. It's crazy. I remember when this happened, I was covering this live during the trial. And I just remember thinking this trial's over. Like, why is the trial not over? And we're going to talk about that too more. So.
Cool. I do not know why it is inverted, but that's the way it was presented, collected and presented from Canton Police.
You see a timestamp or a time and date stamp on the bottom of that. It's in blue.
I cannot know.
Okay. Does it appear that time and date stamp, if you can't read every letter on it, that is in correct order? In other words, that's not inverted.
I cannot read it, no.
All right, let's go and play this for a second. Who is that just got out of the car?
I do not know. I think that's the tow truck driver. He would have the only access to the vehicle. We did not touch the vehicle.
Who's that on the left?
I missed that. I was looking down at the laser pointer. I do not know.
So the other thing is that it makes no sense that the tow truck driver would not have taken pictures, right? Because I can't remember who it was. I think it was somebody in the chat the other night that was saying like, for insurance purposes, right? And this makes total sense. And now that I think of it, right, like the last time I used AAA, like I remember seeing this, like if they, for insurance purposes, they take pictures, right? So that way they can show like what the car looked like before they tow it so that they aren't then later on found liable. Like somebody's like, oh, there's a dent or whatever, right? Or any damage. It's like, oh, that was already there. So that's another thing, right? You know, they must have, I mean, what? So the tow truck driver, I mean, it's just crazy, right? And it makes you wonder if it's like they didn't even need to maybe say don't do it or threaten or whatever, because it's like, oh, Canton PD shows up, right? You just know what to do type thing. Right, exactly. They take pictures prior to, yeah. And what else was I going to say? Like, right. So as far as the tampering, it's like, this is enough. Like, this is enough of a problem. But the fact that that's not the end of it and it's still ongoing and they're still getting more footage coming out and there's still more going on with this, it's, I mean, at what point is Judge Bev not going to be able to continue to just act like it's okay, right? I mean, I just don't know, like, what it would take for her to finally dismiss this. Like, what would it take for her to dismiss this case? I don't know. Can't imagine what else you could possibly need, right?
You know, for a fact, I'm the gentleman that's wearing a dark olive drab state police baseball style hat, and Trooper Mike Proctor is wearing a winter hat.
Trooper Proctor's wearing what?
A winter hat.
Back that up. That was playing, and I didn't realize it was playing while you were talking. Stop. And stop. Yesterday, when you testified, you indicated that the two individuals in this scene were you and Trooper Proctor, correct?
Not correct. There was two individuals in the rear of the vehicle I shined my light to. That was me and Trooper Proctor.
Do you see Trooper Proctor toward the back of the rear of the vehicle there?
I can't tell because of what the head is. I just know that Trooper Proctor was wearing a black hat.
Which the person in that, in the video to the left, to the rear of the car is wearing a black hat, correct?
I can't tell. I don't want to be locked into a statement where later on you show me that it's somebody else magically. I can't testify to that.
There's no magic about this. It's your testimony. I'm just asking you what you see.
I don't see that. No.
So, let's go ahead and play at this point. You see the person toward the back of the vehicle walking toward the opposite side of the SUV?
I do.
What area does he appear to be going to?
He appears to be going towards the rear passenger side of the vehicle, although it does not appear so because the video is inverted, a mirror image. That's where he's going.
And Sergeant Bukhenik, you testified for
So he's using those interchangeably.
at least a half an hour about this video yesterday, correct?
I'm sorry, it was a long day. I don't know the timing of how long I testified.
You significantly testified about this video yesterday, did you not?
I testified about this video.
And you testified that it was true and accurate, correct?
Correct.
You testified that it was reflective of your observations of what was happening in that Lallyport that evening, correct?
I testified that this is a accurate scene and collection of video evidence from the Lallyport.
And as that truck sits in that Lallyport, just like this, it appears from all perspectives that what we're looking at is the passenger side of the car, and that right rear taillight is right there shining in our face, correct? From this perspective.
I'm sorry, can you repeat the question?
From this perspective, from the perspective that the jurors are looking at,
Okay.
from all indications, that would appear to be the right side of the truck, the passenger side of the truck, and that taillight that you can see is the right rear taillight from this perspective, correct?
The way it presents itself, yes.
And yesterday, during the entirety of your questioning by Mr. Lally, not once did you mention that this video is actually completely inverted.
I did not know.
Mr. Lally didn't ask you if it was inverted, correct?
That's correct.
And if I hadn't gotten up here and begun questioning you, that would be left uncorrected, correct?
Objection.
Sustained.
The person with the winter cap appears to walk directly to the what ultimately should be the right rear taillight of this car, correct?
That's the vicinity, yes. That's where he is. Yeah.
And the thing is like, you know, Alan Jackson wants this to come out because of the third party thing and the law enforcement.
I'd like you to pay attention to the right rear of this car. But I know
But
we're completely
Even
back.
beyond that, even again, even if, because I know like a lot of people, myself included, think that maybe there was too much emphasis placed on that. So even if you take that part away, just the fact that it's inverted at all should have been enough, you know?
But it's the far corner of the car. Do you see a person's head there?
It appears as if someone's still there.
And that person is located at or
That
near
I don't know.
what portion of the car?
In real life or as it's depicted?
Is the person near in real life, near
In real life,
the right rear
Or-
taillight?
hold on. y'all,
Yes.
in real life or as it's depicted? You've got to be kidding me.
The car.
In real life or as it's depicted?
Is the person near in real life, near the right rear taillight of the car?
Yes.
Matter of fact, standing there hovering around them, correct?
We don't know the distance that they are in proximity to the actual vehicle. We just know that they're behind the vehicle. That
Looks like it's pretty close, doesn't it, Sergeant?
Objection.
Sustained.
Does that look like he's in close proximity to the right rear tail light?
As I said, I can't tell how far away he is from the vehicle.
His head's right there, sir. You can't tell that he's right next to the right rear tail light?
Objection.
Sustained.
All right. I want you to pay attention to what that person does as soon as the other person comes out from behind that car. So you see him move. Stop it. Do you see that person move?
I saw movement in the frame, yes.
Right when the other person is in eyesight of the person toward the right rear, correct?
I mean, the video speaks for itself.
Yeah, it does.
Objection, Your Honor.
The objection sustained. No commenting, Mr. Jackson. We've talked about that.
I'm going to ask Mr. Bates to back it up because there's one other issue I want you to pay attention to, if you can, right at this moment or right before this moment, and that is the timestamp. We can back it up in maybe 10 seconds. Right about there. Don't play it yet. Instead of paying attention to the individuals, I'm going to ask you, can you see, may I approach the screen, Your Honor?
Yes.
Can you see the timestamp at 5:37 and 37 seconds p.m.? Can you see that from where you're at?
No, I cannot.
Me neither. That's why I don't walk up to it. Let's play it for about 10 seconds. Pause it. Did you see another person just appear toward the rear end of the car?
There was a fog of some sorts. It did appear as if a person was actually in. There was two people back there, and two people walked away, or one person walked away.
The timestamp jumped to 5:38:01. Correct?
I cannot see the timestamp, sir.
Did it appear that there was an anomaly? There was a portion of that video that was deleted, or it's missing, not deleted, but just missing.
Objection.
Can you tell that? Does it appear that way to you, Sergeant?
No, Your Honor, I cannot tell what is happening with the video.
If you take a close look at there's a classic police car in that Lallyport, correct?
There's an antique vehicle there. Yes, yes.
If you take a close look at the trunk of that vehicle, see the word police?
Yes, I believe I can read that. Yes.
And it's backward, correct?
It is mirrored, correct.
That's a good indication that this is an inverted video, right?
It appears that way, yes.
And if we were to fast forward at 5:42.
Yep.
About another 20 seconds. There you go. Can we just play it at this point? Well, you take one pause it. Pause it. You see the Lallyport garage came down?
Yes,
You see a number on the garage?
I do.
Is that correct?
What is correct?
Does the number appear correct? How do you make it 4?
No, the number's in the mirror image, yes.
I just wanted to make the point. Everything in this video is completely backward, correct?
It's not backwards, it's mirrored, reversed. You can look yourself in the mirror in the morning, you still see your own face. It's not backwards.
But my mirror image is not an accurate depiction of who I am. My
Check.
actual physical appearance is who I am, correct?
Objection.
Sustained.
A mirror image, Sergeant, is not an accurate video of this, is it?
Objection.
It's a mirror image by definition.
Sustained. Ask it differently, Mr. Jackson.
Your Honor, thank you. I don't think I need to. I would like to mark I have a we can bring the lights up.
Let's wait.
I have a thumb drive that I'd like to have marked with the court's permission.
Does Mr. Lally know what's on this thumb drive without you telling us?
I do not.
If I may.
We'll come to sidebar.
Sidebar. Yup. Drive the car to the sidebar.
I know that you want to know when this case is going to end, and I don't mean that in any name.
And so we don't, that's it for today on that one. Yeah. Okay. So all right. So here's where we were at in this document here. Right. So Trooper Proctor was in fact standing directly next to the right rear tail light. There we go. All right. The Commonwealth exploited this court's order instructing the defense to disclose its impeachment material in advance of witnesses testifying. AD Lally and MSP Brian Tully huddled with key witness Jennifer McCabe mid-trial, prepped her on how to explain why she never discloses she went to Michael Lank's home one day after John McCabe's death, and then it suppressed exculpatory statements made by McCabe during that session until nearly a month after McCabe's testimony, at which point McCabe and other relevant witnesses were safely off the witness stand. So, so this is redacted. As a result of this extraordinary governmental misconduct, Ms. Reed has been permanently and irreversibly denied her constitutional right to a fair trial. No remedy other than dismissal can adequately address the significant harm caused to Ms. Reed and the injustice of proceeding without the lost exculpatory evidence that was in the Commonwealth's possession. Accordingly, the case against Ms. Reed must be dismissed with prejudice. And then here's the facts. So we don't need to go over all this background. Facts relating to the destruction and withholding of exculpatory CPD footage, video surveillance footage, CPD video surveillance footage, Lallyport. The Commonwealth has produced dribs and drabs of various clips from video surveillance obtained from CPD's DVR system without any accompanying reports, evidence logs, or other documentation regarding the recovery and chain of custody of evidence on at least 4 separate occasions. So on February 2nd, 2022, the defense filed defendant's emergency motion for preservation of evidence. All physical evidence. We've heard about this before in previous filings. Lally stated in open court that he had reviewed the proposed order and had an objection to it. The court ordered a preservation for all physical evidence, including video surveillance footage. In other words, 3 days after O'Keefe's death, the Commonwealth was aware of its affirmative obligation to preserve any and all video surveillance footage in its possession, custody, or control. Ms. Reed's case was transferred to the Norfolk Superior Court, filed a separate motion to compel production of certain outstanding discovery, including all crime scene photographs and or videos taken in connection with this case. Redacted. The Commonwealth has now produced 4 separate incomplete batches of video surveillance footage recorded at the CPD on January 29th, 2022. April 4th, 2024 production. On April 4th, 2024, on the eve of the first trial in this matter, the Commonwealth for the first time disclosed woefully incomplete CPD video footage, which consisted of video from the CPD main driveway and CPD Lallyport front wall cameras. Curiously, the Lallyport front wall footage omitted a 42-minute interval at the precise time the SUV arrived at the Lallyport garage. The missing footage from the Lallyport front wall camera would have captured a close-up of the condition of the SUV's right rear taillight upon arrival at the CPD's Lallyport garage. the individuals who had access to the right rear taillight, and whether anyone removed taillight material from the SUV before the first piece of taillight evidence was recovered at 34 Fairview Road. The condition of the right rear taillight of the Lexus SUV at the time it entered law enforcement's custody is perhaps the most critical and highly contested issue in this case. It is astounding and convenient for the Commonwealth that this seminal time frame is missing from the Lallyport front wall camera footage. Moreover, the data was not preserved in a forensically sound way in violation of the preservation order, which means that the defense has been denied the ability to determine whether the Commonwealth deleted, altered, manipulated, or otherwise lost critical video evidence in its possession that it was obligated to preserve. I mean, I think it's clear that they did do those things. April 10th, 2024, the Commonwealth files its certificate of compliance. So they filed their certificate of compliance 6 days before trial, that they've done their due diligence to the best of their ability, disclosed and made available all items subject to discovery. This representation was patently false. It strains credulity that A.D. Lally, in light of his actual knowledge about the preservation order and existence of extensive Lallyport video, would represent to the court and to the defense that after reasonable inquiry, he disclosed and made available all known discoverable material in his possession, custody, and control. At a minimum, rather than mislead the court and the defense, A.D. Lally was obligated to inform the court and defense that there was outstanding video surveillance footage. There's a footnote here. A.D. Lally was cognizant of other discoverable material that the Commonwealth did not disclose before certifying his compliance with his discovery obligations. Notably, when filing the certificate of compliance, he expressly represented that the lone exception of outstanding discoverable material was some evidence related to DNA testing and analysis. So what does this mean? This means that Lally certified that all the discovery was turned over and the only thing that might have been the exception was something related to DNA, aka not other video footage. So April 23rd, 2024, the Commonwealth produces inverted video mid-trial in violation of Rule 14 and attempts to use that video to defraud the jury into believing that no one approached or touched or otherwise manipulated the right rear taillight of Miss Reed's SUV. I don't know why there needs to be redactions here. Like, it's pretty crazy, right? Like, what the hell is redacted? Okay, on April 23rd, 2024, the Commonwealth produced additional footage entitled Additional Lallyport Video Download Link. No flash drive was presented to the defense. There's a footnote here. The Commonwealth never filed a supplemental certificate of compliance. The Commonwealth subsequently exploited their mid-trial disclosure of this video surveillance footage as part of their attempt to convince the jury that nobody approached or touched the rear taillight of Miss Reed's vehicle after it entered the Lallyport. Good night, Kimmy. I hope you feel better and hope to see you soon. Okay, so A.D. Lally craftily elicited testimony from Sergeant Bukhenik that this interior Lallyport camera was an accurate description of the Lallyport and the SUV when it arrived at CPD, and that, quote, as seen in the video, end quote, no law enforcement officer approached the right rear taillight. Crazy, right? That's eliciting false testimony. On cross-examination, however, Sergeant Bukhenik's testimony was exposed as profoundly misleading at best and perjurious at worst. It became apparent that the video surveillance footage displayed on direct examination was inverted and a mirror image of reality, critical facts which neither A.D. Lally nor Sergeant Bukhenik saw fit to inform the court, defense, or jury. In other words, this video made the left side of Miss Reed's SUV appear to be the right, and the right appear to be the left. Therefore, the video presented to the jury as, quote, fair and accurate, end quote, appeared to show a person, Trooper Proctor, standing near the left rear taillight of the vehicle, where in fact it was the right rear taillight. Moreover, the inverted video does not capture the condition of the right rear taillight, and it conceals Trooper Proctor's presence by the right rear taillight. This leads to the inescapable conclusion that A.D. Lally's questions, Sergeant Bukhenik's responses, and the deliberate introduction of inaccurate evidence was designed to perpetrate a fraud on the court, the jury, and Miss Reed with respect to a critical issue on this case. October 10th, 2024, the Commonwealth produces additional exculpatory video surveillance footage in violation of Brady in Rule 14. Post-trial, on October 10th, 2024, the Commonwealth again provided new footage, this time from the CPD church side exterior, first floor corridor, rear lot main side, and rear lot cruiser side cameras. This footage shows Higgins arrive in the parking lot of the CPD at 1:26 a.m., enter the building, and speak to some unidentified individuals on the phone as he is leaving the CPD at 1:34 a.m. Significantly, this specifically requested material and relevant evidence which establishes that Higgins was on the phone with some unidentified individual at 1:34 a.m. as he left the CPD shortly after O'Keefe's death was suppressed until after the first trial. It never ends. It just never ends. The Commonwealth failed to preserve exculpatory video surveillance from January 29, 2022 in violation of a court order and Brady. On November 8th, 2024, while preparing for Ms. Reed's second trial and in response to the continued piecemeal production of video footage that had not been originally disclosed during the first trial, attorney Elizabeth Little emailed Brennan, again, requesting raw video footage from CPD, which shall include but is not limited to all cameras capturing the CPD and blah, blah, basically, yeah, all cameras, right? And Brennan indicated via email that he would request the CPD provide all requested footage. Ultimately, the defense requested access to the CPD DVR system and drives that hold the recordings from the security camera system so that the defense expert Matthew Erickson could obtain video files and corresponding log files from January 29, 2022 between 12 a.m. and 11:59 p.m. Upon reaching an agreement with the Commonwealth, Matthew Erickson visited the CPD on the morning of December 12, 2024 to image the DVR system. He then discovered, as the Commonwealth has since conceded, that the DVR system was programmed to automatically overwrite footage after 30 days, which means that the Commonwealth failed to preserve specifically requested material. So there's a number of issues here, right? The first one being that obviously they didn't preserve it, right, as they were supposed to, but also, as is obvious, then how the fuck is more coming out, right? Specifically requested material on exculpatory footage relevant to Ms. Reed's case via standard forensic protocols as they were obligated to do pursuant to the February 2nd, 2022 preservation order and October 5th, 2022 order compelling discovery of all videos and related metadata. January 28th, 2025, the Commonwealth produces more exculpatory blurry video surveillance footage, establishing that an unidentified person approaches the right rear taillight of the SUV as soon as it enters the Lallyport garage. On January 28th, 2025, the Commonwealth yet again turned over additional CPD surveillance footage from January 29th, 2022, this time from an exterior camera depicting Ms. Reed's SUV being brought into the Lallyport garage. The footage, although blurry and grainy, appears to show an individual approach the right rear taillight of Ms. Reed's SUV immediately after the vehicle is brought into the Lallyport garage and then exit shortly thereafter. If this video were not blurred out, the surveillance feed would have captured yet another angle of the right rear taillight as it entered the Lallyport garage. At a certain point, it defies logic that all CPD surveillance footage coincidentally cuts out, blurs out, or becomes grainy at the precise time the right rear taillight of the Lexus SUV should be in frame upon its arrival at the Lallyport. This angle of video surveillance is exculpatory and was withheld from the defense prior to the first trial. So now we're back to Jen McCabe, Hoslong. McCabe then took steps to delete that one search out of more than 4,560 on her phone, along with nearly every communication made on her phone in the hours following O'Keefe's death, only some of which were recoverable from her phone using forensic extraction software. The close and long-standing relationship between the Albert and McCabe families and the law enforcement officers assigned to investigate this case is central to Ms. Reed's third-party culpability defense. CPD Sergeant Link, a longtime friend of the Alberts, was the first officer to enter the Albert residence on the morning of January 29th, 2022. In preparation for trial, the defense uncovered location information on McCabe's cell phone, which proved that she went to the first responding officer, Sergeant Link's home on January 30th, the day after John O'Keefe's death. Unbeknownst to the defense, ADA Lally and ADA McLaughlin shared this impeachment information with Lieutenant Tully. On May 10th, 2024, in a then undocumented meeting, Lieutenant Tully, ADA Lally, and ADA McLaughlin met with McCabe shortly before she was scheduled to testify in the first trial. McCabe's materially inconsistent statement about meeting Sergeant Link was not memorialized in any report or otherwise disclosed to the defense in advance of McCabe's testimony at trial in violation of Brady, Giglio, and Rule 14. McCabe testified beginning on May 17th, 2024. During cross-examination, she testified that she received a text from her sister, Nicole, stating, "We'll get more info tomorrow. Don't want to text about it," to which she responded, "Right." When Ms. McCabe was asked whether anything significant happened the next day on January 30th, McCabe volunteered the following story. This is where she says she went to the house and friends, Carrie's friends. She testified she was at the house for approximately an hour and that she might have ran in to go to the bathroom. On cross at trial was the first time McCabe mentioned going to Sergeant Lake's home on January 30th. When pressed further, she admitted that she discussed the issue at a meeting a couple weeks prior at the DA's office. She testified that at the meeting at the DA's office, I was asked, "Oh, were you at Michael Lank's on the 30th? She admitted that at first I said, "No, I've never been to his house." Then I thought about it and I said, "Oh my gosh, yes, I did go there." And that was the extent of the conversation. Jesus. She further testified that Tully did not ask her any follow-up questions about why she went to the personal home of Sergeant Link the day after O'Keefe's death, and that he did not take any notes. Of course not. On May 29th, only after the defense was deprived of the opportunity to effectively cross-examine McCabe and Carrie Roberts about their visit to Sergeant Link's house, Lieutenant Tully memorialized his meeting with McCabe. Lieutenant Tully's May 29th report, which also omitted any reference to McCabe's exculpatory statement in which she denied she ever went to Sergeant Link's house, was not disclosed to the defense until June 4th, 2024. Redacted. Argument. Ms. Reed's constitutional rights to effective assistance of counsel and due process under the laws guaranteed by Article 12 of the Massachusetts Declaration of Rights and the 6th and 14th Amendments to the United States Constitution require that the Commonwealth disclose certain evidence in advance of trial. We don't know why it's redacted. It could be grand jury. We don't know. We just don't know. But it was not the defense's decision. That's clear. I mean, right, Heather, saying, could you imagine being law enforcement, all your friends are law enforcement, having a law enforcement being found on your property, and then you don't come out of your house at all? I know, it's insane. Ms. Reed's constitutional rights to effective assistance of counsel and to due process under the law require that the Commonwealth disclose certain evidence in advance of trial. And then this is just, we know a lot of this, right? Like, obviously they have to disclose, impeachment evidence, right? Any evidence that's favorable to the accused, etc. In addition to her constitutional rights, Ms. Reed also has a statutory right to obtain evidence in advance of trial and prepare her defense. Notably, this prosecutorial duty to produce evidence covered by Rule 14 extends beyond just the prosecutor to all agents of the Commonwealth, including police. Yeah, we know that. So law enforcement, they are a part of the Commonwealth, essentially, right? As set forth herein, the Commonwealth has repeatedly violated its discovery obligations under Brady v. Maryland and its progeny, and Rule 14. The Commonwealth's production of the April 23rd, 2024 inverted video from the Lallyport garage violated Rule 14 and this court's October 5th, 2022 order compelling the production of video evidence. At best, the inverted video had been in the Commonwealth's constructive possession since January 29, 2022. At worst, this video evidence was intentionally manipulated and inverted by the Commonwealth and its agents sometime thereafter in an effort to defraud the jury into believing that no law enforcement officer approached the right rear taillight of the defendant's SUV upon its arrival in the CPD's Lallyport. Either way, the Commonwealth's production of the inverted video in the middle of trial and after it had filed its certificate of compliance violated Rule 14. Yeah, and Heather says the whole point of having these specific things must be disclosed is to literally prevent this exact type of shit. Yep. The Commonwealth violated Rule 14 and Brady by withholding exculpatory impeachment evidence establishing Higgins was speaking to some unidentified individual on the phone at the CPD at 1:34 a.m. So it shows him arrive at the parking lot at 1:26 a.m. on the phone. The Commonwealth, namely ADA Lally and ADA McLaughlin, suppressed exculpatory impeachment evidence and then redacted. Crazy. And then we're back to Lallyport here, unfettered access. This camera angle should have had a clear and unobstructed view of Miss Reed's taillight as it was driven into the Canton Lallyport garage. However, yet again, the footage is too blurry and grainy to make out the condition of the taillight. Notwithstanding the fact that the footage is exculpatory and shows an individual approach the right rear taillight of Miss Reed's SUV immediately after the vehicle is brought into the Lallyport and then exit shortly thereafter. This video footage has been in the Commonwealth's possession since January 29, 2022, and was withheld from the defense for 3 years and only produced after trial in this matter. This video surveillance footage directly contradicts Sergeant Bukhenik's false testimony at trial, in which he claimed that the video surveillance footage established no one from law enforcement approached the right rear taillight of Miss Reed's vehicle. Miss Reed's defense at this trial in this matter was that law enforcement removed taillight material from the Lexus SUV and planted the evidence at 34 Fairview Road. Notably, no taillight material was found at the crime scene until after the Massachusetts State Police took custody of Miss Reed's vehicle and after it arrived at the CPD Lallyport. And then they're referencing Brady again. Commonwealth failed to preserve exculpatory evidence in violation of a court order. To be clear, the condition of the right rear taillight of the SUV at the time it entered law enforcement custody is perhaps one of the most critical and highly contested issues in this case. No kidding. The footage that has been produced by the Commonwealth is rife with issues, that's an understatement, that call into question its accuracy and forensic viability of the CPD's video surveillance footage obtained from the Lallyport. The Commonwealth has produced numerous video files without any way to verify their authenticity. These video files include a file capturing the interior of the Lallyport garage with a 42-minute gap missing at the precise time the feed would have showed an unobstructed view of the right rear taillight of Miss Reed's 6,000-pound SUV as it entered the CPD Lallyport garage, in spite of the fact that the Commonwealth claims the video surveillance feed is motion activated, right? And that's why I mentioned that thing or the story a bit earlier about my neighbor with the cameras, because and the lights, because motion activated, right? And even when Yuri Bukhenik said, you know, a bird landing could activate it, right? So it's like, this is just insane. The mid-trial production of an inverted video produced by the CPD in an attempt to save face for the gap in footage, which improperly depicts right as left, and left as right, and falsely suggests that no one from law enforcement approached the right rear taillight in a blurred out video that obstructs what would otherwise be another clear view of the right rear taillight of the SUV as it entered the Lallyport garage on January 29th. It is not a coincidence that none of the many cameras in the CPD's Lallyport garage captured the condition of the right rear taillight upon its arrival at the CPD and before the first pieces of taillight lens material were recovered by law enforcement at 34 Fairview Road. I mean, I don't even know. I don't know that never, maybe. How long till Bev doesn't suck. The fact that the Commonwealth and its agent, CPD, failed to preserve the footage in a forensically sound way and allowed critical evidence to be destroyed is not a coincidence and goes to the heart of Miss Reed's defense and the credibility of some of the Commonwealth's most central witnesses. Even if ADA Lally were not aware of the footage, a reasonable prosecutor exercising due diligence would have been aware. ADA Lally had an ethical, statutory, and constitutional obligation to obtain this footage. Following the February 2nd, 2022 preservation order, ADA Lally should have, and a diligent prosecutor would have, promptly notified CPD to preserve any existing footage and inquired about whether the DVR system overwrites or deletes old data. The certificate of compliance ADA Lally signed and filed with this court specifically includes a representation that the prosecution made a reasonable inquiry to disclose and make available all discoverable evidence. ADA Lally did anything but, and the Commonwealth is responsible for the resulting loss of this critical exculpatory evidence, which cannot be cured short of a dismissal of the case. Couldn't agree more. Couldn't agree more. There's nothing to cure this. Now, the one thing I will say is that the only thing that's interesting, well, not the only thing, but one thing that's interesting here is like they did not make this, at the time that this happened in the first trial, right? They did not make a motion to dismiss at the time. And that's the thing, right? Like we were talking about earlier, like when this happened in the first trial, it was like, okay, isn't this trial over? But they didn't ask for it to be over. And why is that? Well, my opinion is because they were sure that they were going to get an acquittal and they wanted the acquittal. And that's the only thing that could be problematic here, because what we're seeing here in this motion, right, are things that have to do with the first trial, right? That, in other words, some of this could pertain to the upcoming trial, right? Like the fact that they're still getting pieces of this video evidence coming in, right? But then others of this, it's like, for example, like Jen McCabe, right? And like, those are and testimony from the first trial. I hope it's not going to be problematic for them. You know, you don't want to give Judge Bev any reason to deny this, right? And in other words, some of these things, in my opinion, there should have been a motion to dismiss at the first trial for these things when they happened, and then a subsequent one now, right? With all, in light of all the new information regarding the videos and whatnot. So, okay. The Commonwealth withheld exculpatory The Commonwealth withheld exculpatory statements by McCabe in flagrant violation of its obligations under Bright. Again, this is pertaining to the first trial, right? So how is this going to help them here? I don't know. The Commonwealth withheld the exculpatory statement of McCabe in which she denied traveling to the personal residence of First Responding Officer Sergeant Link. Again, I just don't think that this is the strongest argument. And if they were going to make it, they should have made it at the time. Commonwealth's egregious and repeated discovery and Brady violations require dismissal of this case. So basically, this is where now we're seeing where they're taking in all the shit that happened in the first trial and kind of grouping it in, right? Sort of to say like the totality of it, right? Which I get, but I still just hope it's not going to be problematic that they didn't file something at the time when these things were happening in the first trial. And now they're making it an issue now, where, you know what I mean? Like, it's a little bit too late, you know? And the thing is with what's been going on recently with all the new footage coming out, that to me, that's still enough, right? Like for a motion to dismiss as it pertains to this upcoming trial. Like, I don't know why you couldn't have done both. Like, I don't think it would have hurt the defense. But again, the reason I think they didn't, even though that maybe would have been the smartest thing to do, is because they wanted it to proceed on to deliberations for the jury to return a verdict of not guilty. And I think that that's what they were wanting. So okay. Right. The Commonwealth's egregious and repeated discovery and Brady violations require dismissal of the case with prejudice. Okay. When the Commonwealth fails to comply with its discovery obligations, the court has the ability to impose remedial sanctions. Dismissal is appropriate as a remedial sanction as a way to cure any prejudice caused by the violation of a discovery obligation and ensure a fair trial. Citing a lot of case law here, which is awesome. We like to see that. I think a lot of this goes without saying, and it just seems like, you know, common sense. Alternatively, prosecutorial misconduct that is egregious, deliberate, and intentional, or that results in a violation of constitutional rights may give rise to presumptive prejudice. In such circumstances, dismissal would be appropriate if needed to create a climate adverse to repetition of that misconduct that would not otherwise exist. So kind of like, in other words, to deter it from happening again. Dismissal is the only appropriate remedy for the Commonwealth's egregious and repeated non-compliance with its discovery obligations. Given the extreme governmental misconduct in this case and the irreparable nature of the harm to Ms. Reed as a result, dismissal is appropriate and necessary under both legal principles outlined by the Supreme Judicial Court. The first trial resulted in a hung jury precisely because this was a close case. Had the Commonwealth produced the exculpatory footage and exculpatory statements to which Ms. Reed was constitutionally and statutorily entitled, the result of the trial very well may have been different. Instead, the Commonwealth engaged in repeated instances of withholding exculpatory information from the defense in a concerted effort to undermine the defense's ability to effectively confront and cross-examine the Commonwealth's seminal witnesses in this case, including Sergeant Bukhenik, McCabe, and Higgins. Moreover, the Commonwealth's continued piecemeal production of the exculpatory video footage, which has by definition been in the Commonwealth's possession since January 29th, is a flagrant violation of the Commonwealth's constitutional and statutory obligations. Furthermore, the Commonwealth's gamesmanship in withholding the exculpatory video surveillance footage from the CPD and failing to properly preserve this exculpatory evidence has irreparably harmed Ms. Reed. To this day, the Commonwealth has not produced all of the video surveillance footage recorded at the CPD on January 29th. Numerous camera angles and large swaths of time are missing. As a result, the Commonwealth's failure to appropriately image and preserve this evidence, video surveillance footage which would have captured the condition of Ms. Reed's right rear taillight at the time it was taken into police custody from multiple camera angles, has now been destroyed forever. Absent the destruction of this evidence, which has been in the possession of the Commonwealth and its agents since January 29th, the defense would have conclusive evidence that Ms. Reed's taillight was cracked, not shattered, when it arrived at the conflicted CPD on January 29th. If the taillight was largely intact and only cracked rather than shattered and missing 47 pieces, as the Dighton police officer Sergeant Barrows testified he observed earlier in the day, the evidence would establish Ms. Reed's innocence and be case ending for the Commonwealth. And in bold and italics, it should not be lost on this court that this video surveillance was destroyed in the Commonwealth's possession in direct violation of a preservation order. As a result, Ms. Reed is left without the ability to forensically examine the CPD's DVR system to determine whether the many random clips produced by the Commonwealth in discovery have been altered, manipulated, or tampered with, and whether other clips may have been destroyed. Footnote 6. Unsurprisingly, the Commonwealth is utterly unable to establish any chain of custody for the footage, let alone explain how it had come to be inverted. Ugh. Unlike the other surveillance footage obtained by MSP in this case, the CPD video surveillance footage was never logged into evidence. There are no reports documenting the recovery of the evidence, and there is no documentation regarding its chain of custody. Insane. Insane. They did not call the tow truck guy. I don't know why. The Commonwealth's failure to preserve and produce this, at least I don't think they did. And I feel like I asked this, someone asked this question the other night, and we were able to confirm that they didn't call him. My memory is they didn't call him, but it doesn't make sense. Like, it's like, why? I don't know why no one called him. The Commonwealth's failure to preserve and produce this exculpatory evidence, which includes the destruction of all original and native video surveillance footage and the accompanying log files, has irreparably harmed Ms. Reed. There's no lesser sanction that can cure the Commonwealth's failures to preserve this evidence. Exclusion of the video surveillance footage at trial would undermine Ms. Reed's defense because the footage itself is exculpatory. So this is important because, in other words, they're not asking for the video footage to be left out. Like, in other words, they're not like trying to suppress that, right? They're not saying to exclude it. In fact, I think they want it to come in. And so that's what they're saying, right? That to exclude it wouldn't be the right remedy here. Indeed, the very nature of the evidence is such that exclusion harms rather than helps Ms. Reed. Well, there you go. The exculpatory evidence to which Ms. Reed is constitutionally entitled is permanently lost. Therefore, the Commonwealth's misconduct can be remedied only by dismissal of the case. These were not innocent mistakes. The repeated and flagrant discovery violations engaged in by the Commonwealth and its agents were intentional and designed to bring about a wrongful conviction. Here at trial, ADA Lally, the Commonwealth, and its agents intentionally withheld surveillance footage from January 29th. The Commonwealth sprung inverted surveillance footage on the defense in the middle of trial, as well, and in violation of Rule 14, as well as its certificate of compliance, and then it compounded the violations by attempting to perpetrate a fraud on this court and the jury. By knowingly eliciting false testimony from Sergeant Bukhenik on direct examination, the Commonwealth violated the ethical prohibition against presenting knowingly false evidence to the trier of fact. The inverted footage of Ms. Reed's vehicle from this interior Lallyport camera was unquestionably a false account of the true facts, and the Commonwealth passed it off as an accurate depiction of the SUV when it arrived at the CPD on January 29th, and that, as seen in the video, no law enforcement officer approached the right rear taillight. Moreover, both ADA Lally and ADA McLaughlin were caught withholding exculpatory information from the defense at the first trial. The Commonwealth's underhanded decision to surreptitiously reveal impeachment evidence to McCabe in advance of her trial testimony and then withhold her exculpatory statements to law enforcement is a gross violation of the Commonwealth's constitutional obligations under Brady and its progeny. Even after trial, ADA Brennan located exculpatory video surveillance footage, which was withheld from the defense at the first trial, and established Higgins made a phone call at 1:34. This exculpatory impeachment material was never turned over to the defense. Do I find it odd that the first trial was streamed to the public and now a second trial is looming? I find a lot of it odd. I'll just say that. Indeed, as discussed above, the Commonwealth's misconduct has resulted in a violation of Ms. Reed's constitutional rights as to give rise to presumptive prejudice. Discovery violations in this case constitute a Brady violation and thus violate Ms. Reed's due process rights. Right. It's just a tool used when they need to, of course. Yeah. Given that these facts rise to presumptive prejudice and considering the need to create a climate adverse to repetition of that misconduct, this case should be dismissed. The Commonwealth's clear, repeated, and intentional failure to comply with the discovery order requires an appropriate remedy in this case. Because the discovery violations concern a failure to produce and preserve exculpatory evidence, and because exclusion cannot remedy the violation, the only appropriate remedy is dismissal of the case. Because of the Commonwealth's egregious misconduct, including repeated and intentional delays in providing discovery, withholding of material and exculpatory evidence, and failure to comply with court orders, Ms. Reed's constitutional right to a fair trial has been irreparably and irreversibly harmed. No proceeding against her can satisfy the constitutional requirements of a fair trial. Then they're asking to dismiss the case with prejudice. Dismissal is the only appropriate remedy. So now they're talking about dismissal of a juror. I just want to note here, United States v. Lafitte. If you guys can see, can you guys see my mouse? You probably can't see it. It won't let me highlight it. But basically, a couple lines up from the bottom here, it says see United States v. Lafitte. That is Russell Lafitte, as in Murdoch related. Jury and there's Remmer. Oh my God. Remmer. I love it when we get overlapping with Murdoch because Remmer is all over it, right? With Murdoch and in the appeal. And oh my God, love it. We know all about Remmer. We know all about Remmer. Triggers a burden on the government to prove that the tampering was harmless to the defendant. Remember, we've talked about this with Murdoch, right? The different prongs, right? And the Remmer standard there, you know, was there interference? And then the second prong being like, was it prejudicial? Was it harmless? And so anyway, Remmer says it's puts a burden on the government to prove that the tampering was harmless. Okay, and then a hearing. So this is about the fact that they never had a hearing to ask the jurors about their verdict, basically, right? Again, there's so much overlap with Murdoch here because that's literally what they had to do. They had to bring in the jurors and ask them questions, and we covered that hearing back when that happened. And that was the first thing people thought about. Like when this whole thing happened, when the jurors started coming out, it was like, yeah, the example everybody went to was Murdoch because they had a hearing and they were able to inquire without getting into the jury deliberations, because that's the thing. They can't get into their deliberations, but it's totally possible. And that was a great example of that. Conclusion. For the above reasons, Ms. Reed respectfully requests that this honorable court grant the defendant's motion to dismiss for extraordinary governmental misconduct with prejudice. Although dismissal is required and appropriate under the circumstances, in the alternative, the defense seeks and is entitled to an evidentiary hearing on these issues attendant to the Brady violations and juror interference. The evidentiary hearing will require testimony from a number of witnesses, including but not limited to ADA Lally, ADA McLaughlin, ADA Brennan, Lieutenant Tully, Chief Rafferty, Trooper Proctor, Sergeant Bukhenik, Colleen Crawford, and other members of CBD, and Lieutenant Fanning. So the juror interference thing. Okay, so here's the affidavit. So juror interference, I think that has to do with one of the jurors that was an alternate that was like dismissed or whatever. I think that comes up here somewhere. So affidavit of Alan Jackson. So he's just noting all these exhibits. On October 10, 2024, after trial in this matter had concluded, the Commonwealth produced additional exculpatory video surveillance footage from the Canton Police Department establishing that Brian Higgins made a phone call. Yes. The video surveillance footage, which is attached here to as Exhibit K. Oh, man, I wish we could see it. Special Prosecuting Attorney Hank Brennan indicated that he located this video footage on some sort of electronic device in a box that was in the actual possession of the Norfolk County DA's office. The defense has set forth credible and unassailable evidence establishing that the Commonwealth has engaged in numerous and egregious Brady violations. Okay. Exhibit A. So this is from February 2nd, 2022. For the preservation of evidence. Exhibit B. So this is just going through all the different times that they were requesting this certain discovery. Let me go further down here and see. There's a certificate of compliance, Michael Morrissey, redacted. So they're in chronological order. So let's see. It's loading. Exhibit Q. Okay, redacted. Redacted. I'm just, because these are going to be the more recent exhibits that he just referenced. Are they all redacted? What a shame. Yep. Oh. Okay, there you go. Okay, so now, next up. Just find it. Oh, right. I got that document. Right. Okay. There's the Commonwealth's opposition. Let me see here. Okay, so this is the next one. Okay, so I've got all these documents. All right, so here's what we need to do. Let me share this to you guys. And what I need to do is, let's see here. Mark this. Okay. Let me unshare, reshare real quick. Okay, so now we have the Commonwealth's opposition. This was filed on February 20th. You guys ready? Actually, there's something we need to watch real quick. I have a clip. Let me pull this up before we get into this because, let me see here. Give me just a second. I had prepared something here. The plausible deniability of it all. Okay. Hold on. Okay, here we go. Okay, so this is from live stream on February 7th, 2025. This is just a little clip talking about Brennan's involvement in this case. So from February 7th, 2025. Hank Brennan's plausible deniability.
And in fact, it's not just doing, it's like, if you participate in that, you can lose your bar license, right? Sanctions, but like more than just sanctions, right? And like, you have a duty to report these things. You have a duty to not participate in it. And if you do participate in it, bad things. And so that's just to this end, giving him an out is very astute point because, you know, if Mr. Brennan, it's risky, you know, it's just risky. And it does make one wonder, is that partially why they brought in another person who doesn't know? I mean, I don't know, like, obviously it wasn't working as it was before. And, you know, they tried to bring somebody else in, but you could also think like, well, by doing that, by bringing in a special prosecutor who doesn't already know the history, is there almost a plausible deniability so that they're less likely to get into these issues where they have a responsibility to make things known and to, you know, I don't know. Do you guys see what I'm saying? You know, it's like all the secrecy within the office, right? And they all kind of seem to know what's the different levels of secrecy. And then they bring in a new guy who doesn't know. Mm-hmm. So then he can't accidentally say what it is, right? Sort of like with with think about like these different cases where there's like a hitman involved, right? What's the point? Well, separation of powers. You want to make sure that the hitmen have no idea who hired them and who the person on top is, right? Because the idea is like, even if they do want to tell all, they can't give the information because they don't know it. Similar idea, right? You bring in somebody new and just hope they don't discover some of the shit. And then it's like, well, then it's less likely to come out into the open. I don't know, just thoughts.
when there is a Brady violation, and there is no question that that's what's before this court.
Mhm.
Discovery and Brady obligation, Brady violations. The Commonwealth doesn't, the court.
Yeah,
may
they're
remember-
probably just hoping he wouldn't discover some of the shit, right? But he's not in. The thing, he's not in on the secret. He's not from the local club, the local crew, as it were, right? The boys' club or whatever. You know, I'm referencing other things there, like you know, that's the good old boys' club is kind of how they talk about it in Murdoch. But anyway, he's not a part of that, right? And so, yeah, I wonder if that was part of that strategy.
By the way, on the witness stand, when these videos were coming in piecemeal, especially the inverted video, 2 or 3 witnesses all went like this. I wasn't the one that downloaded it.
Speaking of the 7 degrees of separation.
I don't know where it came from. It just ended up on my desk on a flash drive. I don't know where it came from. Everybody was pointing fingers at everybody else.
Yeah.
Nobody could establish a single chain of custody.
Okay, so I don't know what you mean here, Heather. Did someone respond? I don't know what that means. Okay, so now there's a reason I wanted to pull that up, because that was what we were talking about on that live stream. And boy, oh boy, is that ever relevant to what we're about to read here? Because this is Hank Brennan, right? All right. So the Commonwealth's opposition. Comes now the Commonwealth in the above caption matter, The Commonwealth disputes any ethical violations or misconduct, let alone misconduct that taints the legal system or infringes upon the defendant's right to a fair trial. The defendant's motion should be denied. Dismissal as a sanction is a very strong medicine, and it should be prescribed only when the government misconduct is so intentional and so egregious and appropriate only upon a showing of irremediable harm to the defendant's opportunity to obtain a fair trial. To the extent the defendant has suggested that egregious circumstances might warrant dismissal, the Supreme Judicial Court has noted that we have never dismissed charges in such circumstances in the absence of prejudice. Judicial responses should be limited to truly remedial, not punitive measures. The Commonwealth does not dispute its prosecutorial obligations and constitutional duty to disclose in a timely manner exculpatory evidence over which it has possession, custody, or control. Okay? Nor does the Commonwealth dispute its broad obligations to inquire and disclose any facts that would intend to exculpate the defendant or diminish her culpability in all statements of witnesses. However, to prevail on a claim that the prosecution failed to disclose exculpatory evidence, the defendant must first prove the evidence was in fact exculpatory. Exculpatory evidence includes all evidence that tends to indicate the guilt of the defendant or provide some significant aid to the defendant's case. Well, I think they've done that. And while rightfully broad, the conception of exculpatory evidence is not boundless. Canton Police Department surveillance video. Oh my God. In 2022, the Commonwealth provided the defense with approximately 90 crime scene photographs. This is where it just gets like, I just get nauseous. Here's what we want to think about, guys. Of all the different issues raised by the defense, what are they addressing here? What are they responding to? Because that's the point, right? If you're opposing it, you should be responding to the points that were brought up from the moving party, right? Whatever they brought up. The Commonwealth provided the defense with approximately 90 crime scene photographs depicting the condition of the defendant's vehicle in the Canton Police Department's Lallyport. I don't remember anywhere in that defense filing, there was nothing in there about we didn't get enough photographs. That was not anything that was mentioned. Okay. Further provided to the defense was ring surveillance video of the defendant's broken rear taillight at approximately 5 a.m., which would have been after it would have been fucked with, right? Statements of witnesses who observed the defendant's broken taillight around 5:30 a.m. Again, after that would have been fucked with, potentially. Or no, I guess it would have been before. I guess it would have been before, actually. Yeah, it would have been, sorry, let me just correct that. That would have been before. So what they're saying is, in other words, okay, here's what I think he's getting at. In lieu of providing the Lallyport footage that shows the taillight, right? The condition of the taillight before it could have been fucked with. He's like, look, we gave you this other stuff. The ring video, witnesses who observed it at 5:30 a.m., observations of a damaged taillight by Dighton police, and automated vehicle location data from troopers' cruisers who were assigned to the CERT team, evidencing that the CERT team was on Fairview Road before the defendant's vehicle arrived at the Canton police station. The defendant's vehicle arrived on the back of a the defendant's vehicle arrived on the back of a flatbed tow truck at the Canton police station at 5:30 p.m. The defendant has also repeatedly represented in the media and postured at trial that her taillight was broken at 5 a.m. by striking the victim's parked vehicle in the driveway of the victim's home. The Commonwealth has provided substantial evidence, including accident reconstruction video from its expert, Judd Welcher, demonstrating otherwise. So I guess that's what we're going to see at this upcoming trial. Side note, Kenny Kinsey. You guys remember when I freaked out in that hearing? I think it was in January when Hank Brennan referenced Kenny Kinsey. And I was like, huh. And here's what I said about Kenny Kinsey. If you guys recall, I said, he is the most credible, reliable expert witness of all freaking time. And if the Commonwealth brought him in as an expert witness, whatever he testifies to, I would take 100% at face value. And Hank Brennan referenced in that hearing something from Kenny Kinsey that, and I don't remember exactly what it was, but it sounded to me like they were, like they had a report from Kenny Kinsey, right? Like he assessed the case and he kind of quoted something that Kenny Kinsey had said in like a report. And we talked about this because I was saying, you know, here's how it goes with Kenny Kinsey. And we heard him say as much because we actually went back and rewatched his testimony from Murdoch, that when he's asked by anybody to review a case, he's going to look at it and he's going to tell you what he thinks. And that's what any good expert witness would do instead of being like a quote unquote hired gun. Now, that's why I thought it was interesting, because if he reviewed the case, Kenny Kinsey, right, and provided anything that could be helpful to the Commonwealth's theory of the case, and they called him at trial, I would take what Kenny Kinsey says it's 100% trustworthy in my opinion. He's extremely fair, and you know, given what we know about this case, I would imagine that anything that he would say would probably be something that could go either way, right? Because I don't think that anybody could actually come in and say that the damage to the taillight was from a person. I just don't think it's possible, right? Nobody who's reputable would do that. You know, you had Trooper Paul and that was it. So makes me wonder about this Judd Welcher dude, right? But what's interesting is we never heard anything else about Kenny Kinsey. So that makes me wonder if what happened again, Kenny Kinsey reviewed everything, took a look at it and said, here's my opinion. And it did not fit with the Commonwealth's theory of the case. And so therefore they're not going to call him a trial. And I think that's probably what happened. I'm going to look up Judd Welcher and see what I can find here. You guys want to see who Judd Welcher is? Let's see. All right. Accident reconstruction biomechanics. Now remember, one thing to know, as we know, right, that Judge Bev has ruled over and over again that only somebody who has who's a doctor, like a medical doctor, can testify as to the cause of the injuries. So when you think about the ARCA dudes, right, you've got the ARCA dudes, and then you've got Dr. Russell, right, and she can testify about the injuries to a certain extent. So it makes you wonder, like, we're going to find out what his dealio is. Did they find someone who does both? Because if he doesn't have an MD, he can't testify as to the cause of the injury. But this is who they're going to call, looks like. Accident reconstruction, vehicle, okay, crash data. So he's a biomechanical engineer and accident reconstructionist with Aperture. Specializes in trauma causation, Does not look like he's an MD. Okay, Bachelor of Science in Mechanical Engineering, Master of Science in Biomedical Engineering. So he's not an MD. He's not an MD. So he cannot testify as to the causation of the injuries to John O'Keefe. Can't. I mean, it looks like he's, qualified, right, for accidents, as it pertains to the vehicle, right? So in other words, this is their replacement for Trooper Paul, basically. Akhtar. Yeah, this is their replacement for Trooper Paul. They got a real person. That's good, at least. Crash testing, crash simulation. Okay, accident reconstructionist. Now remember, Kenny Kinsey is a crime scene reconstructionist. So, and it's, again, they had that one reference to Kenny Kinsey in that hearing, and there hasn't been anything else yet. So again, to me, that would make me think that he didn't offer them anything that they wanted to use because it didn't fit their theory of the case. What's what now, Twiz? What's what? What the what? Okay, so now back to the document. Wait a second. That's not what hold on. Shared the wrong thing. Hold on. Here we go. Okay. So, where was it? Oh, I can answer this question. That Cy Ray would say the same thing that Kenny Kinsey said, which is like the side that if you're a reputable expert, then whoever it is that asks you to take a look and like start, you always start as an expert by like consulting, like you're going to take a look and review the case, and then you go from there before they go ahead and pay for like a report and all that shit, right? So, but any reputable expert witness is going to say that they are not hired gun, quote unquote, which is to say they're going to look at it and then they're going to just give you their objective opinion. In other words, you can't buy their testimony, essentially, that they're going to just tell you, here's what it says, and then you can either use it or not. And so, and that if they do, and then if they choose not to use the expert, it's because it doesn't fit their theory. And I think that's what happened with the Commonwealth and Kenny Kinsey. Okay. So yeah, so now we know for sure that we've got, where did he go? Judd Welcher, that's our Trooper Paul replacement. Beyond unsupported claims and vague innuendos, the defense struggles to establish how the condition of the defendant's broken taillight in the CPD Lallyport is in fact exculpatory or the most critical and highly contested issue in this case. I disagree. Despite claims to the contrary, the defense never filed a motion to preserve or its perpetually evolving theory of the case. What? Hold on. The defense never filed a motion to preserve or in its perpetually evolving theory of the case. Perpetually evolving theory of the case? What? Did the defendant specifically request? Footnote 1. The defense claims that their request, okay. The defense claims that their request for all physical evidence, including anything present on or near the decedent at the time his body was discovered, anything found at the alleged crime scene, was sufficient notice to the Commonwealth to preserve footage from the CPD. Here's the thing. This is bullshit. Here's why. They can't know what needs to be preserved. That's why it's broad. We were just talking about this earlier with when I was covering the Delphi stuff, because of how the most important thing you can do is get an attorney right away and have them preserve shit. They don't know what they need, right? Until, like, that's the whole thing. When a crime first happens, nobody knows what's going to be important, so you preserve it all. However, in this case, the Commonwealth is calling the vehicle a murder weapon. They're literally saying the vehicle is a murder weapon. They literally said that in the first trial. They literally, in fact, to the extent that when Lally was talking about the murder weapon, and I was really fucking confused. And then I was like, oh my God, he's talking about the car. He's talking about the car. It was like in closing arguments. So one would think that the Commonwealth itself would want to preserve it. The car, the shit with the car, right? That's the murder weapon. It's like in another case where you've got a gun that's a murder weapon, and it's like the gun, like because sometimes they don't find the gun. It's like for example, it's like in a case where the gun is recovered, the murder weapon is a gun, the gun is recovered, and then the law enforcement's like, you don't need this, and they just lose it. Be like, what? It's like that. Oh, okay. Nevertheless, the trial prosecutor was not aware of the existence of surveillance video in the CPD's Lallyport until receiving the federal grand jury transcript of Michael Proctor. Prior to that, the prosecutor had not been alerted to its existence by existing officers. Not an excuse. That's not an excuse. If law enforcement knows, you remember, you guys got to keep in mind, they're all the same entity, right? As all the case law was just cited in the defense's motion. They're one and the same. The state, law enforcement, Commonwealth, the prosecuting attorney's office, it's all the same. So to say, oh, I didn't know, it's not good enough. Promptly on April 4th, 2024, the Commonwealth provided the defendant with 9 surveillance videos in its possession, consisting of video footage of the main driveway. Okay, Lallyport. Notably, the quality of the video is poor in certain portions. However, that is the condition it was recorded in and the condition it was received by the prosecutor. Why? Is that how it's always done? Like, that question I would have here is, can we see, what does it normally look like? Like, why is it so shitty? Like, this makes no sense. Not to mention, we already know that, like, for example, some of the newest footage that was provided is like blurrier and grainy than even the other shit, right? Like, it's exceptionally blurry and grainy. Like, in other words, it gets worse at times. But there's also nothing to back this up. There's nothing to say, there's no affidavit. There's nothing here to say from like an expert saying like, here's why it's like this, right? You can't, dude. The Commonwealth has produced, oh my God. The Commonwealth has produced evidence that since January 2022, the Lallyport camera was replaced due to its defective condition. And during the first trial, the Commonwealth called the technology director for the town of Canton to testify about this. Yeah, but that had nothing to do with any of it. He had nothing to say about it being shitty. Oh my God. The Commonwealth filed a certificate of compliance on April 10th, 2024, noting that to the best of its knowledge after reasonable inquiry. To the best of its knowledge. Well, unless you are a rock, your knowledge sucks. It's not good enough, and it's not an excuse. It disclosed all information subject to mass crimp. Parties were in court on Friday, April 12, 2024, to argue motions limine. During the defense's televised motion to admit third-party culprit evidence, Attorney United made representations about the Canton PD's surveillance videos. Following that hearing, Brian Tully sent prosecution team members an email stating, I spoke with Chief Rafferty. She reviewed the video of the SUV arriving at CBD exists, and we should have it contrary to what the defense represented on Friday. So it was only after it was brought up in a pretrial hearing that they went back and looked and said, okay, it exists. You've got to be kidding me. The video depicts the vehicle entering the Lallyport and crime scene tape being put up. She's putting it on a thumb drive for us. So you've got to be kidding me. Why are you citing this? Does he think this is good? This is the opposite of what you think, Brennan. This proves that you had it all along and you didn't turn it over until the defense said something in a hearing, and then you're like, oh wait, we do have it. You've got to be kidding. The prosecutor had not previously reviewed this video or knew of its existence. No excuse. You should have reviewed it. You should have known of its dude. Subsequently, the prosecutor requested that both the Massachusetts State Police and Canada Police Department produce all relevant material surveillance video. On April 23rd, 2024, the Commonwealth provided the defense. Okay, and then this is the inverted video. Notably, what was produced to the Commonwealth and provided the defense was inverted surveillance footage due to the camera settings. Why? How and why was it only that one video? Due to the camera settings. According to who? How? Where's the proof? Oh my God. 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 God. Right. Heather, I think you're saying this was in reference to my example with like the gun analogy, I would imagine. And yes, exactly. Why else would they get rid of it, right? It would make no sense. If you really have the murder weapon, that proves your case. I mean, like, for example, in Murdoch, right? Take Murdoch. One of the only issues that the state had was like they never found the murder weapons, right? And that wasn't, obviously they were able to prove it without that. But like that was, in some cases, that's a big deal. Like where it's like, well, we don't have the murder weapons. If you have the murder weapon, you use it. Like, duh, if you're law enforcement or if you're the state. Who's Melissa Twiz? Melissa, or you're saying coming over on Franks? I don't know what you're talking about. Okay, so all right. Okay, got my goat handy, comfort goat. All right, ready? The Commonwealth did not manipulate or alter any video and entered as a trial exhibit the video in the condition it was received. Contrary to the defense representations that the Commonwealth's intention was to mislead or deceive the jury by introducing the inverted video, the defendant fails to mention that after the defense altered the evidence to correct the image to appear consistent with the human eye, the Commonwealth played the entirety of the corrected yet altered video, which reveals that Juror Proctor is standing feet away from the defense vehicle and never touched the rear right taillight. Further omitted from the defendant's filing is the fact that Trooper Proctor's DNA was not on the right rear taillight. What? Who cares? Not to mention, weren't they all wearing fucking gloves? Anyway, after the trial, a certified forensic video technician employed by the Norfolk District Attorney's Office reviewed the surveillance footage that had been previously produced to the defense. Recognizing that the video was extremely dark with minimal visible detail. Why bother with cameras then? Seriously. Like, what is even the fucking point? The video technician clarified the video footage, and on October 10th, 2024, the Commonwealth produced to the defense clarified videos, reports detailing the forensic clarification process, associated hash values, and or as Brennan called them in that one hearing, hashtags, and extracted still images from the Canton Police Lallyport. Oh, that was the same hearing, by the way. When he said hashtags, he also said cache instead of cache. Furthermore, the video technician clarified video images from the Canton Police Cruiser camera footage and other things. Great. Each depicting the same damage to the right rear taillight, and encapsulated those images in a substantive report provided to the defense. Now, here's the thing. Like I was mentioning before, right? The things about like the issues from the first trial and then the issues for the second trial. So, for example, right? To the extent that any of this is true and things are clarified and blah, 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 that would matter for the upcoming trial, right? But they didn't have this at the first trial. This was all missing. The discovery was missing from the first trial. But the only problem, again, could be the fact that these issues were not brought forth at that time. That's the only thing I worry about. I don't know what you guys are talking about, but it's okay. Okay. After trial on August 21st, 2024, the Canton Police Department provided the Commonwealth 2 additional videos. Video from the interior Lallyport camera on January 1st, 2022, depicting that camera captured all video in an inverted fashion. Oh, okay. Interesting. Okay, so here's what, so remember we were saying, like, where's the rest of the video? What does it look like on the rest of the day? So this is interesting. So they said they supplied video from January 1st. Just January 1st, 2022, that it was also inverted. But you know what matters more so is before. Not to mention, when did they say they replaced the cameras? They replaced the cameras, hold on. Wait a second. Where was it? I don't remember where it was. There was a part where they said they replaced the cameras in 2022. Anyway, I was just noting that that to say that they have videos or footage from January 1st, that's also inverted. But you know what would matter more is what was it like before wait, hold on. So one day. So, okay. So January 29th was the day in question, right? So they have video from January 1st, but only that one day that's also inverted. Trying to prove like, oh, it's always inverted. But like that, okay. One day? You gotta be kidding me. Right. In an inverted fashion to rebut the defense's suggestion that the video had been tampered with. Consistent with the witness's trial testimony is video from the interior hallway and exterior of the Canton Police Station that shows Brian Higgins at the Canton Police Station during the early hours of January 29th and depicts Mr. Higgins moving his law enforcement vehicles due to the snowstorm. These videos were provided to the defense on October 10th. Prior to their production, the prosecutor was unaware of the existence of these videos. Not an excuse. It's your job to know. They exist. That counts. The defense boldly claims that the surveillance video of Mr. Brian Higgins in and outside the Canton Police Station proves that he perjured himself for a federal grand jury. This claim is extremely prejudicial and false. In support of this claim, the defense cites, federal grand jury transcript. Further, the defense is unable to just demonstrate any prejudice. Both Brian Higgins and Brian Albert were thoroughly cross-examined at trial about their phone calls with one another. Oh, the 22 seconds of it all. Additionally, the Commonwealth provided the defense with 167 pages of access card swipe records. On January 28th, 2025, the Commonwealth provided the defense with surveillance video from the main driveway that depicts a different camera angle of the defendant's vehicle arriving at the Lallyport. Notably consistent with other videos received from the Canton Police Station's Lallyport, the quality of the video is poor. There's absolutely nothing depicted in this video that is exculpatory or undermines consistent evidence that the defense right rear taillight was broken and pieces were missing prior to the vehicle being towed from Dighton. Prior to late January 2025, the prosecutors had never seen this video, not an excuse. After directing a review of all physical and data files, this video was located within a paper case file of investigators. What the fuck is that? What is that? A paper case file? Okay. But all of this does is this proves the defense's point, which is this. This shit existed and you didn't turn it over. It's your job. I mean, it would have been Lally's job in the first trial, and now it's Brennan's job. I mean, at least they're finding it now, but like that doesn't fix anything. And again, this just again goes back to the point of like some of this stuff, it would be bigger issues for the first trial, but now they have it, right? For the second trial. After inquiry, it was learned that an investigator obtained this video from the Canton Police Department in 2022 and it was placed in a physical case file and never provided to the prosecutor or Why? What the fuck? Although the prosecutor was wholly unaware of this video until recently, not an excuse, the Commonwealth does not dispute that the video was in its custody during the defendant's first trial. Had the prosecutor known about this video, it would have been produced as every other video could. Dude. What do you mean? What's next? Wow. Okay. Even in circumstances where the prosecutor fails to disclose evidence a defendant is entitled to receive, there must be a showing of irremediable harm to the defendant. This court must examine the extent to which the defendant was disadvantaged in defending herself when considering the prejudicial quality of exculpatory material evidence. Quote, in measuring prejudice, it is the consequences of the delay that matter, not the likely impact of the non-disclosed evidence. And we asked whether the prosecution's disclosure was sufficiently timely to allow the defendant to make effective use of the evidence in preparing and presenting his case. The defendant cannot show irremediable harm to her right to a fair trial as it relates to the Canton Police Department surveillance video. While the production was untimely, the poor quality of the video makes it difficult for either party to benefit from. Furthermore, this video depicts the same event that was contained on the surveillance foot, but different angles, dude. Okay. Oh, yeah. Simply just from a different camera angle. Simply just, look at this. Further, while the Commonwealth would argue that the videos from the Canton Police Station Lallyport are inculpatory, the defendant benefited during the first trial by suggesting without any substantive evidence that the poor quality video and or gaps in time due to an improperly functioning camera system were caused by an improper police investigation and systemic police misconduct. In November 2024, the defense made an informal discovery request relative to Canton Police Department videos. The Commonwealth and Canton Police Department facilitated the request, and on December 12, 2024, in the presence of the defense expert, it was, okay, so this is this whole thing. Nearly 3 years after the incident that the footage on the DVR was overwritten and the system no longer maintained. So this is when they had that, they sent the expert out, right? This also marked the first time the defense had made any request for metadata or logs pertaining to these videos. What now? What now? A video of a suspect video. That sounds Inception-y. Are you saying, because I keep just accidentally saying getting video and vehicle mixed up? I mean, so many V words, right? Okay, quote, a defendant who seeks relief from the loss of or destruction of potentially exculpatory evidence has the initial burden to establish a reasonable possibility based on concrete evidence rather than a fertile imagination that access to the lost or destroyed evidence would have produced evidence favorable to his cause. If he meets his initial burden, a balancing test is employed to determine the appropriateness and extent of remedial action. The courts must weigh the culpability of the Commonwealth and the materiality of the evidence and potential prejudice to the defendant. Yeah, sounds great. Let's get rid of this case. Let's be done. Here, the defendant fails to meet her initial burden. She has presented absolutely no evidence that a forensic copy of the Lallyport surveillance video with metadata and logs would have been exculpatory. Rather, she relies upon innuendos and unsubstantiated allegations that are speculative at best and not the equivalent of concrete evidence. Your mom's not concrete evidence, Brennan. Right. Yeah. No, I figured it out. Eventually. Yeah, the vehicle and video. Yeah, I know. Dinkins, it says. Even if this court were to engage in a balancing test, dismissal would be inappropriate as there's no evidence of egregious misconduct on part of the Commonwealth, and any potential prejudice stemming from the overwritten videos could be remedied at trial. The defendant can point to no evidence of bad faith on behalf of the Commonwealth, nor any of its agents, particularly where the Commonwealth is equally aggrieved by the poor video. The Commonwealth is equally aggrieved, guys. Poor Commonwealth. Fuck me. An inability to obtain a forensically extracted copy of the surveillance video to fully disprove the defendant's repeated and baseless allegations of evidence tampering. You wish you could read what? Okay. I'm glad I got the multi-pack of batteries for this goat. I think I've got like 12 more left because I feel like we're going to wear it out. Okay. So the Commonwealth is equally aggrieved by the poor video quality and inability to obtain a forensically extracted copy of the surveillance video to fully disprove the defense repeated and baseless allegations. Okay, statement of McCabe. In violation of the defense's discovery order to produce all reciprocal discovery, including impeachment evidence to the Commonwealth prior to the start of the trial, it was during the third week of trial that the defense produced reciprocal discovery to the Commonwealth regarding location information of Jen McCabe's cell phone. 3 days later, on May 10th, 2024, in anticipation of her trial testimony, the Commonwealth met with Jen McCabe, as it does with all witnesses. On May 29th, 2024, Lieutenant Tully wrote a police report memorializing the meeting and explained, when asked why her cell phone would have been in the area of the residence of Sergeant Michael Lank on January 30th, 2022. Jennifer stated she was with Carrie Roberts, who was picking her daughter up at the residence. She did not speak. Commonwealth produced Lieutenant Tully's report. That report wasn't available. I didn't have it until after Ms. McCabe testified. Doesn't matter. Was given to counsel prior to testifying. Jackson vigorously cross-examined Ms. McCabe. Notably, Commonwealth produced Lieutenant Tully's report once it was available to the defense. Furthermore, Carrie Roberts testified. Again, I don't think that this whole thing with Jen McCabe is the strongest issue. I mean, the Lallyport video, right? Okay, this is the thing I'm more interested about, this juror dismissal thing. The defendants claimed that a lieutenant of the Massachusetts State Police was in charge of jury security is patently false. Because see, a lot of that was redacted in the defense's motion. So at no time did Lieutenant John Fanning have contact with nor control or influence over the trial jury, nor was there any jury tampering that deprived. Okay, interesting. The defense's brazen misrepresentation previously proffered in media interviews in direct violation of the impoundment order of juror discussions and sidebars solely to mislead the public and jeopardize the integrity of the judicial proceedings are false and dishonest misrepresentation. The executive branch of government is separate and distinct from the judiciary. I think we know that. I think Judge Bev knows that. The governance of the jury is solely within the power of the trial court and sworn court officers. The defense's first trial raised significant safety concerns for both parties to effectuate, the buffer zone. Okay, the court ordered a buffer zone. Additional law enforcement resources were available in proximity to the courthouse. As a superior officer assigned to the Norfolk County Detectives Unit, and the only supervisor who was not a trial witness. Lieutenant Fanning was one of the commanding officers who was involved in the safety and peacekeeping efforts occurring outside the courthouse. Interesting. So this Fanning dude, he's all up in the Sandra Birchmore case. He was like the one who covered it up. I always forget the police officer's name who did all that, which is fine because he sucks. I'm sure one of you guys will remember. I always forget his name. I don't know why, but again, it's fine because he sucks. But Lieutenant Fanning is like responsible for helping cover that up, from what I recall. Yet somehow the defense conflates the fact to misrepresent that Lieutenant Fanning therefore improperly influenced and tampered with the jury. To do so, the defense omits. I mean, wild though, right? That he was like, with all the overlap with that case, like in terms of like Garino and other Massachusetts State Police and all that. And then adding to that the fact that Fanning was outside the courthouse for this trial, that's insane to me. Wow. I love sloths. They're one of my favorite animals. I call them sleuthies. They're one of my faves. Does anybody now see now it's going to bug me that I can't remember the name. Okay. Well, it doesn't matter. Okay. I'm sure I'll think of it when I'm not trying to. So peacekeeping efforts, right. Yet somehow the defense conflates the fact to misrepresent Lieutenant Fanning, therefore improperly influence and tamper with the jury. To do so, the defense omits the remainder of ADA McLaughlin's statement to the court. And then this is redacted. I don't want to know what she said. Okay, so this is the interview. Okay, they said that Lieutenant Fanning was the very person governing the jury. Attorney Jackson also stated, despite representations in this court filing, they had no specific evidence of jury tampering. And let me know, guys, if you want to go through and watch that interview and break it down. We can totally do that. I actually kind of meant to do that, and I was planning on doing that because the day that came out was like the same day that Turtle Boy had the interview with that juror. So I was literally going to do a live stream covering that interview, and then that juror interview came out. I did that instead, and then I forgot about the interview. But we can still go through that if you guys want. However, conveniently omitted from the defense's filing and extrajudicial statements is the following, and again, it's redacted. At no time did Lieutenant Fanning enter the Norfolk Superior Courthouse. Moreover, he never saw it alone, spoke to any member of the jury. There's no evidence that dismissal of the juror was improper. I wonder if the juror that they're talking about here is the one that was also an attorney. Just a thought. In conclusion, in sum, the defendant's motion should be denied. The defendant can show no irremediable prejudice to her right to a fair trial, nor has the evidence in good faith shown that the Commonwealth engaged in prosecutorial misconduct. I disagree. You suck. So this is for the Commonwealth, Michael Morrissey. So Morrissey wrote this. Huh. That's interesting to me. Matthew Farwell. It was just good try. Matthew Farwell. That's the name of the law enforcement officer of the Birchmore case. Okay. Oh, thank you. Thank you. Yep. Thank you. Okay. So now let me go to the next thing. Okay, go my folder here. Boop, 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 boop. Opposition. So now we have, okay. So next up, we have this one. Okay, so this is the defendant's motion to amend the scheduling order. Now comes now. All right, here we go. It never ends. The defense was informed late yesterday afternoon, so February 26, 2025, by Special ADA Hank Brennan, that the Commonwealth has, guess what, guys? Additional discovery to turn over to the defense. Imagine that. Specifically, alleged chain of custody reports relating to, guess what? The Lallyport videos. Just when you thought it couldn't get any worse. Today, February 27th, 2025, Mr. Brennan confirmed that he expects to provide those reports by tomorrow, February 28th morning. During the same phone call today, he further informed counsel that the Commonwealth will be producing Lallyport videos to the defense on Monday morning. It is unclear whether the videos, and so Monday morning, that would have been today. It is unclear whether the videos to be produced will be duplicative of what has already been produced or whether this will be new material. 4, new chain of custody reports, which the defense does not have as of the date and time of this filing, will directly impact the motion to dismiss and cause the defense to modify its motion. In light of this new information, therefore, the motion to dismiss is not yet complete. So what we just read, the motion to dismiss, they're like, it's not complete yet. 5, the Lallyport videos in the Commonwealth's possession that have been described as having been stored on the department's video file system. This new information, okay. So now, okay, this is new information, right? Like it says that the Lallyport videos have been on the, so we saw something about a paper file or whatever, but there was also all that talk of that retired detective. I mean, now it's like the department's video file system. This new information will undoubtedly impact our written submissions and or oral argument. These videos, according to the Commonwealth, are not expected to be turned over to the defense until March 3rd. Again, that would have been today. Considering the above, the defense expert expects to file a supplemental addendum to our motion to dismiss, but this obviously cannot be done until we receive the outstanding discovery. As such, we are requesting a continuance of the hearing on the motion to dismiss, which is supposed to be tomorrow. Okay? The hearing for tomorrow. So that we can analyze the additional information, confer with our expert, and file an addendum to the motion to dismiss. The defendant respectfully requests that the hearing on the motion to dismiss be moved to some date after the production of this information, but no earlier than the week of March 17th, particularly given the number of other critical deadlines that we are working to meet next week. They're supposed to go to trial on April 1st, guys, by the way, which includes satisfying all of our reciprocal discovery obligations, filing all motions in limine, and attending 4 separate hearings in relation to this case, 3 before this court and 1 in federal court. Fucking hell. They need to clone themselves. Failure to allow Ms. Reed sufficient time to properly or appropriately address and brief these constitutional issues. So this is a no-brainer, right? They need to move that out. Now we have more things. We have y'all. Oh, Meg gifted another membership. Thank you. Awesome. Thank you. Appreciate it. Happy for that. Okay. Oh, that's fucking hilarious. The goat woke you up. There you go. See, that's what the goat's here for. Oh, that's interesting. His twin brother, so talking about Farwell, was also involved in some stuff with Sandra. Interesting. Heather's green now. Sweet. Yay. Whee! I mean, I'm with you, Meg. I totally agree on. Yeah, for sure. Honestly, it's funny because I always thought that like as in chats, right? But even looking at StreamYard here, you know, where it looks the interface is a little bit different. It's a lot easier to see. It really is. It's really funny. And so it makes it easier for me also. And the orange and the green pops. I love it. All right. So now guess what? Commonwealth's opposition to the defendant's motion to amend they're opposing, dude. No. Okay. You guys, they're like, here's more shit. Commonwealth's like, here's more shit. And it's like, oh, well, you know, on the eve, literally, like basically, okay, what did we just read? What we read was they were expected to be handed this new discovery today, as in the day before the hearing. We don't know if that even happened or not, but they're supposed to be getting this information and then the next day have this hearing on the motion. Like, are you joking? Commonwealth's opposition to the defendant's motion to amend the court's scheduling order. Now comes the Commonwealth and respectfully request that this honorable court deny the defendant's request to continue the non-evidentiary motion hearing on the defendant's motion to dismiss for extraordinary governmental misconduct. In accordance with the scheduling order, the Commonwealth filed its opposition. That's fine. That's not the problem. Commonwealth objects to any continuous will be preferred. Dude, I mean, I'm sure they're still having a hearing tomorrow. You know, it's going to be a fucking shit show is what I can say. What do you mean, Twiz? You had to Google orange YouTube tea? What does that mean? In order to make it your picture? You're going on a goat hunt? Are you saying you want to get yourself a goat? Okay, we've got another document here, my friends. So there were more documents that came out today. You guys may have heard or seen or heard, or both. And as you guys have heard me say, finding all this shit when you don't have like a assistant person or whatever is like, it's just not easy. So I don't have all of it yet. I was hoping to get all of it before the live stream, but I only had time to grab one thing. I could still look for it while we're here if you guys want me to go through the rest of it, because there's a lot of filings. But part of the challenge is you have to know the names of the filings to even find them, and then even sometimes then it's difficult. But I was able to get this one. So this is one of the ones I was most excited about from the cursory look that I was able to see if there's new things, right? And I was like, oh my God, because this is related to the ARCA dudes, right? This is crucial for me. Hi, Happy Annie. Woo! Happy to see you again, my friend. Durable. Yeah, we love the goat. So, okay. So Claire, because the number of issues, right? So it's just like, here's the whole other thing, right? Who all temporarily forgot about the things with the ARCA dudes and the payment and whatnot as we were going through all that fuckery? I did. So now we've got this clarification regarding statement in defendant Karen Reed's opposition to Commonwealth's motion to exclude employees of ARCA LLC. Comes now the defendant and files the instant supplemental affidavit of Elizabeth Little, clarifying the following statement, which was included in the defendant's opposition to ARCA, which I prepared and filed. Quote, the Commonwealth's motion to exclude these exculpatory expert witnesses who were not hired or paid for by the defense is not made in good faith and is a desperate and transparent attempt to keep exculpatory testimony of neutral expert witnesses from reaching the jury in this case. And that's from the Commonwealth's opposition. To be clear, the defense did not hire, retain, or pay ARCA LLC to engage in the reconstruction, analysis, and or testing that was performed by ARCA in connection with this case. The defense did, however, reimburse ARCA for the following time and expenses after trial and after the defense received the ARCA invoice dated July 12th, 2024, which was provided to the Commonwealth in reciprocal discovery on February 20th, 2025, prior to the filing of the opposition. 1, travel expenses and time associated with traveling to the Norfolk Superior Court, total of 0.75 hours in phone calls. So less than an hour of phone calls with the defense for coordinating their attendance at voir dire and discussion regarding their background, time spent testifying in court, and the experts' internal preparation for voir dire and trial testimony. So the question that I still have that we don't have an answer to yet is, were they expecting to get paid? That's really, in other words, there's questions that we need, if what I would think needs to happen here is asking the ARCA dudes, like, what the dealio is, and then also getting in touch with, what was his name? I'm forgetting his name, but the dude from the DOJ's office, right? Because this can be clarified as to who knew what when, right? July 12th. And so that was after the trial, I believe, that invoice, right? So, because part of the thing too, right, was like, what my thought was like that, my thought, and this still can be true, right? Like, in other words, where I'm at right now with it is like that the ARCA dudes were expecting to get paid, but they would not, maybe they didn't know who was going to be paying them because there was a lot of confusion surrounding that whole thing. Remember the pause email and stuff? And so it'd be one thing if they had already communicated and they knew that the defense was going to pay them before the trial. That'd be one thing. However, none of this rises to the level of fuckery we see from the Commonwealth, right? So there's that. Turtle. Okay, so to be clear, the defense did not hire, retainer, pay. Okay, no, I already read this part. So the invoice dated. Okay, I read all that. Right. Okay. The defense did not know what, if any, expenses they would be responsible for covering until after trial in this matter concluded and they received instruction and guidance from the U.S. Attorney's Office. Okay, wait, hold on. That's important. Let me go back to the beginning of the sentence. Hold on. Okay, here we go. Literally the questions I was just asking, maybe it was like, keep reading, right? The defense did not know what, if any, expenses they would be responsible for covering until after trial in this matter concluded and they received, there it is, right there. That's it. Literally all that. I could have just kept reading. That's the answer. They did not know what they would be responsible for until after the trial and after they received instruction and guidance from the U.S. Attorney's Office. Okay. So there you go. That's what they're saying here. So yeah, I don't know what Ratgate is. I don't know what Ratgate is, if anyone wants to fill me in. Right. Correct. That's exactly what I was thinking. They knew they would get paid. They were conducting federal. They didn't know what the defense was going to pay. Yeah. Yep. I mean, that's the thing, right? Because they were working for the DOJ. And, you know, everything that we saw and we've talked about in the previous from, you know, the other hearings and stuff was like, it was such an unusual situation. And basically nobody really knew what was going on, but that didn't matter nearly as much as like get them here for trial. Right. And then, you know, the pause email, and then there was no other correspondence until after the trial from the DOJ. I guess it wasn't even until they got the invoice, right? The invoice was a surprise to them. The invoice was a surprise to them. And they're like, wait, what? And then he called the DOJ. So, oh, that's hilarious. Oh, actually, I think Twiz said something about that. That is freaking hilarious. Why was there a rat? What the hell? Oh my God, that's funny. Did you guys get to see the rat? Was the rat on the live stream? Was he cute? So I know there's other filings. Let me see if I can find anything real quick. Okay, there's the ARCA. Okay, hang on. Let's do it this way. All right, let's do it this way. Hold on. Oh, if I do it this way, I can't zoom in. Crap. That sucks. That's too tiny for anyone to see. Fuck. Okay, hold on. Hold on. That's funny. Yeah, I heard something about the bike, the drunk bike and the rat. That is really funny. Glad he didn't die. So this is so frustrating. I wish there was a way I could freaking zoom in. Is there another way? Okay, give me a second. I mean, I can read it, but this is silliness because I want you guys to be able to see it. Unless y'all are fine with it. But like, I mean, honestly, it's tiny even for me, but see, I've got another monitor that's large. So it's a little bit larger than the computer, but not that much larger, but like I can read it. Let me know. Control. Oh, thank you, Twiz. Let me see if that works. Control plus sign. Plus, do I have a plus sign? There's okay. Oh my God. Wait, hold on. Is it making it bigger? I see the thing, but it doesn't look any different. Hold on. Like it popped up. Hold on. Where'd it go? Where'd it go? It's not doing it. Plus, like I'm clicking it. You guys can't see it. Oh my God. It's zooming in on, you see what it's doing? That's what it's doing. It's zooming in there and it's not making the document any bigger. That's hilarious. That's hilarious. Okay. Wow. Wow, 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 wow. Is it getting harder? That's what she said. Meg's just listening, so she's like, it's okay for her. Hold on. Let me just see what I can do here. Give me a second. Oh my God. Oh my God. Oh my God. Okay. Hold on. Oh, goodness. That's a good trick, though. Thanks, Twiz, for that. Oh, that's a cute squirrel photo. Sorry. Let me try to find this. Oh my God. There's a picture of George Anthony. Fievel. Sorry, I'm looking through. I just took a screenshot. I'm looking through all my photos. Where is it? Come out wherever you are. It's got to be in this area here. Oh my God, I can't see it. Okay, here's what we're going to do. I'm going to read it. I'm going to read it because this is okay. Oh my God. Okay. I'm going to read it. You guys ready? All right. Supplemental app. So this is filed, by the way, on March 3rd. Supplemental affidavit of defense expert Matthew Erickson in support of defendant's motion for reconsideration. So this is their tech expert, dude. I'm Matthew Erickson, do hereby depose and state that the following is true to the best of my knowledge and belief. I am a computer. Okay, we don't need to worry about that. He's saying what he is. He works for USA Forensics. On December 11th, 2024, I traveled from Phoenix, Arizona to Boston, Massachusetts by plane to render expert witness services in the above captioned matter. The purpose of my trip was to allow me to extract surveillance video from the Canton Police Department's Exact Vision DVR system in a forensically sound manner which aligns with methods accepted and commonly used in the digital forensic community, as well as review any video preserved within the system from January 29, 2022, between 12 a.m. and 11:59 p.m. I visited the Canton Police Department on December 12, 2024 to do so. After photographing the relevant DVR equipment, I began recording audio and video and then assessed access to the system. Initially, it appeared to me that there were only 30 days of video history and consequently that the relevant footage had not been preserved. That impression was confirmed when I navigated to the appropriate section of the DVR system where a search by day and time could be performed and ran a search for January 29th, and that search returned 0 results. Based on the size of the drives, the percentage used, and the remaining usable drive space, I concluded that there was mathematically no possible way for the videos from January 29th to be present in December of 2024 when I performed the search, unless they were manually saved and or properly preserved via standard forensic protocols. I determined that the relevant activity logs were also gone. Ruh-roh. What are we getting from New Zealand? I love New Zealand. It's on my bucket list to go there. Yeah, a pet rat. He could have a pet rat. He could. I mean, what happened with the rat? Did y'all ever get any? Like, what happened? Like, what was the next step? He fell out of his chair, and then what happened to the rat? Is the rat okay? Rat in a ball. Okay, so the relevant activity logs are also gone. The way CPD technicians extracted the video data from their DVR system is insufficient for forensic purposes. Not surprising. And has resulted in the permanent loss of the original surveillance video data. The CPD DVR system, like most, stores videos in a proprietary format. CPD uses the DVR interface to pick and choose which videos to save, and then that data is converted by the system into a playable format. The resulting file is almost always of a lesser quality than the original, and because it exists in a different format, the resulting file will not hash verify to the original. As such, forensic experts cannot properly test the authenticity of and integrity of the video footage. Due to the Commonwealth's failure to preserve the original footage, I was unable to extract the DVR system footage from January 29th. To obtain relevant footage between 12 a.m. and 11:59 p.m. As previously arranged and agreed upon by all parties. I informed that the Commonwealth may have additional video surveillance footage from January 29th that is being stored on a separate electronic device. You've got to be fucking kidding me. Known as the Canton Police Department's video file system. What the fuck is happening? It is imperative that this additional source. So this is what was just referenced when they asked to continue like the hearing for tomorrow, right? Remember when they mentioned we just got more shit and we're supposed to be getting it on the 3rd. This is the thing. This new thing, video file system. You've got to be kidding me. It is imperative that this additional source of information be preserved and dealt with in a forensically sound manner, as it may serve as another source of information linked to the authenticity and integrity of the video surveillance at issue in this case. It's like every time the defense does something and is like, right? Then the Commonwealth's like, oh, look, we found more. Imagine if there had never been a second trial, right? Look at all the stuff that all this discovery that would have never been uncovered. If the Commonwealth has an individual simply drag and drop, end quote, these files onto a USB drive, all associated metadata will be destroyed or otherwise unverifiable. The proper forensic protocol for preserving this critical information and obtaining the relevant data is as follows. I have no idea. The rat owns the house now. That's really funny. The rat hid in the bathroom the rest of the night. Oh my God. Poor rat. I hope he didn't hurt the rat. I really hope he didn't hurt the rat. I'm just saying. Rats are nice. Rats are people too. Yeah, it's a huge fucking problem. This is insane. This is absolutely fucking insane. And you know what? Again, and it was highlighted also by, we were just reading in one of the many filings, right? The part about how right before the first trial, because, I didn't cover anything before the trial. So right before the first trial, remember the whole reason why they got that inverted video in the first place was because they had a hearing, right? And the Commonwealth only turned that over in response to something that Mr. Unetti said. So like they had it, but then they never. So it's just the same thing. It's literally the same thing. This entire time. Oh my God. A forensic image should be made of the operating system drive as well as additional drives where these video copies may be stored. And then in parentheses, it says, if stored on something other than the operating system drive. And we heard something about a paper file at some point. I don't know how you can have a Lallyport video on a paper file. Maybe that explains it, right? If they're trying to use paper to make Lallyport videos, that could explain all this, honestly. I mean, crayons, paper, that could explain it. The operating system drive is critical in this situation as it will provide key information about the handling, modification, and creation of these video files. Without a forensic image of the operating system drive, all independent and forensically sound verification methods would be impossible to perform. Additionally, any relevant dates that are present in the available metadata would reflect the dates and that the most recent copies were created, and not the actual dates on which the initial copies of these video files were made. For these forensic drive images, we request that they are uncompressed, unsegmented, and preferably in raw DD, double D format. Double Ds. So there we go with that one. Making one of those, right, exactly. The flip books, for real. That's it. I think this all the time. Twiz is saying, I want to know what Brennan would say if she was his client. I think this all the time. Because he's a defense attorney, and this blows my mind. It's like he's been poisoned. And I was thinking this to myself, actually, earlier today, that, like, if I was somebody in Massachusetts, God for fucking bid, right, and I, like, got convicted or accused of a crime, right, and arrested, charged with a crime, whatever, I would not use him as my defense attorney. Prior to this, maybe, right? But in other words, like, if I was somebody who's like a criminal defendant, I would be, to me, this should crumble his practice as a defense attorney, because literally, this is what's so shocking, right? Because what kind of defense attorney are you if you like literally don't care about constitutional rights? I mean, that's an understatement. This just goes so far beyond that. And it's like the puppet, right? That's why I played that video clip earlier about the plausible deniability. It's like he's a puppet for the Commonwealth and for Lally. And it's so funny. I pointed this out on another live stream, but when he first came on, the first hearing or 2 hearings, he kept accidentally referencing the opposing party as the Commonwealth. Like whenever he would go to refer to the defense, he would say the Commonwealth. And the reason is because he's so used to arguing as a defense attorney. So whenever he's thinking about the opposite party, the opposing party, he would say the Commonwealth. And I pointed it out because I thought it was fucking hilarious. I was like, he's a defense attorney. He's just so used to saying it. You know, he would say the Commonwealth or he would say the government. And it was so interesting how by like this second or third hearing completely changed to where he seemed more like neutral, like he wasn't making that mistake anymore. And like now it's completely different. It's like he's drinking the Kool-Aid and like it's crazy. It's crazy because this is the type of thing where like the number of violations here, he should pull a I'm forgetting her name, Erlinda Johnson from the Alec Baldwin case. Remember how in the face of all of the Brady issues, she walked. She was like, I'm not going to be complicit in this. I don't want to lose my bar license. That's what he should be doing. He should be walking and saying, nope. I came on, I agreed to do it, but now that I'm seeing all the shit, I'm not going to be complicit. Right. I can understand if the case was legit. Absolutely, Heather. You should be able to represent either side fairly. Absolutely. And that is 100% true. And in fact, what do we know? Most defense attorneys, I think Bob Mata might be one of the only exceptions to this, were formerly prosecutors, right? Most attorneys have done both because that's how they teach you when it comes to the law. They teach you to be able to, and you guys have heard me talk about this all the time. Like when I was doing my paralegal certificate, we had to do that too. We had to be able to argue for both sides because that's how you do it. It's not about bias. It's about assessing it and going through and doing the analysis and finding the case law. And the point is that with the same set of facts, you can find case law to support either side of the argument. That's the whole point. And so to completely agree, he should be able to represent either side fairly. And that's what I expected initially, right? And then we saw it transition. And there was a turning point. I don't know, maybe it was like a month and a half ago or so. I mentioned it on the live stream. When the turning point happened, I said it. I was like, this is a turning point. It was where we saw things change for him. And it was like, oh, okay. Yeah, he of all people should have and know an understanding of defendant's rights more than absolutely. Right. It's so funny. Bob Mott is so funny. And in fact, I will also say too, like, it's funny. Like EDB, I would say is as livid as anybody with this shit. And I'll tell you why. Because she's kind of an exception too, similarly to Bob Mata, where she only worked as a prosecutor. But having said that, you know, she was the DA, right, for Los Angeles. So Los Angeles, right? And, you know, Alan Jackson worked for her, you know, in her office back in the day. And but here's the thing. She, as a prosecutor, and, you know, it's what you would hope for, right? As a prosecutor, had such a, and still does, even though she's not a prosecutor anymore, but such a sense of integrity for that office, for doing it the right way. It's how it should be done. It's just like when you think about, like, same thing with law enforcement, right? When they do the right thing. Like, remember there was that one law enforcement officer in the Zachary Hughes trial that we loved. I'm forgetting his name now. No, hold on. It was Master Deputy Wolf. Do you guys remember Master Deputy Wolf? And he had the kind of big ears. Heather, I know that will help you remember. Remember how great he was? And it was like he literally did his job, chain of custody, subsequent search warrants, literally just testify. I mean, he was exactly what you want from law enforcement. There was no narrative. It was just literally, he did everything by the book, and he was phenomenal. We were all like, yes, sir. Thank you. You know, just as a recent example. anyway, but the point being, when somebody from the government does their actual job, and I will tell you, like, it's crazy because EDB gets so mad about this case from a different side. And it's not, instead of, it's like from the defense attorney, it's from the prosecutor perspective, which is, how the fuck are they getting away with this? Right? It's like she was saying how, like, this was so offensive to her because she said, your first job as a prosecutor is to find all of the discovery and turn it all over. Like, first things first, right? And like and over and over again saying, like, your job is to seek truth. It's to find the truth, not just to prosecute, like, you know. So anyway, it's just interesting, like, to hear, in other words, because she's so, what's the right word? Just offended by prosecutors behaving like this. It strikes her at her core of her, from her profession, that people, and I get it, right? I totally get it. Same thing for defense attorneys. And so anyway, it's just interesting that, like, every attorney, no matter what their background is just so beyond livid with this case. For no matter what their perspective and background is, it's just really funny. Yeah. Nope. Okay, so next, let's see if we can pull up another document here. Hold on, let me see. Oh my God, now it's all zoomed in. Hold on. Oh my God. No. If I do control minus, hold on. Oh my God. Twiz. Oh my God. Oh my God. Help. I can't even see where StreamYard is. What is going on with this thing? Hold on. What do I do? What do I do? Oh my God. Help. I don't know what you guys are looking at. I can't see. This looks so weird. What is happening? Me trying to unzoom has just done weird things. What is happening? How do I, hold on. Oh, okay. Hold on. Maybe that, okay, that helps. Hopefully you guys, goodness, what I was seeing was very odd. Okay. Yeah. Right, of course. And I pointed that out too. I think it might have been before you were here. Yeah, there was nothing to support any of his argument in the opposition. There was no affidavits. There was nothing. There was some case law, but there was nothing as far as the videos and stuff were concerned. Wait, Vinny still thinks she was hit by a car? How is that possible? Okay, let me, that was funny. Okay, let me pull up the next thing here. Goodness. Okay, we're not going to make that mistake again, hopefully. Okay, cool. Here we go. Yay. Okay. I don't know. That terrifies me. I don't know. That's weird. Okay, so again, I'll read this to you guys since it's tiny. That's what she said. Commonwealth's notice of discovery comes now. So some reports. Oh my God. Copy of Trooper Tully's notes to MSP report. Copy of Dr. Crosby addendum. Copy of transcript of unredacted Gretchen Voss interview. Copy of another Gretchen Voss interview. Copy of email to Special Prosecutor Hank Brennan. And this was filed on March 3rd, by the way. Copy of email to Special Prosecutor Hank Brennan. Another email to Hank Brennan. Another bunch of emails to Hank Brennan, a bunch of them. It doesn't say who they're from, by the way. Copy of voicemails for Hank Brennan, copy of MSP report, copy of Canton Police Department report, copy of something else, bait stamp. I wonder if this is another Lallyport video. It doesn't specify. There we go. So it's just, there's more discovery coming in as of today. And remember when we heard from the defense saying that they're expecting more shit to come in on March 3rd, right? This is the shit that they got. All the shit. And then they have a hearing tomorrow. Crazy to argue on the motion to dismiss. Okay, this is the other big one here, I think. So this is the defendant reconsideration of portion of February 18th, 2025 court order denying, this is a long title, defendant's motion to compel production of a forensically sound copy of the January 29th, 2022 video surveillance footage in law enforcement custody. That's the title. This is filed today. And basically they're saying it's reconsideration, motion to reconsider denying the motion to compel for the forensically sound copy, Lallyport video. Yeah, I don't remember the timeline of when the Odin stuff came out, so I can't say anything, but I don't remember when that came out. Time is a construct. All right, comes now the defendant and respectfully requests that the court reconsider the portion of its February 18th court order denying the defendant's motion to compel production of a forensically sound copy of the January 29th, 2022 video surveillance footage in law enforcement custody. In denying defendant's request for metadata underlying these critical videos in law enforcement custody, the court indicated that there is no affidavit of an expert or any evidence before the court that the procedure agreed to by skilled. You know what? Hold on. Let me see something. Here's the thing. I'm not going to read this now, and here's why. This is a longer motion, and this is going to be important. And I'm going to want to make sure I can do the thing where I make it where you guys can see it and I can see it better. Because, yeah. So I'm not going to read that one yet. Let me see if there's another filing that's like another short one. Because that one's more substantial. So we'll want to make sure, and it's just hard to do that while I'm live streaming. And I don't know, I think that was actually I think that's all the new filings actually. So so this is the big one. And it takes, like, just so you guys know, like, it takes time. Whenever you've got these documents that are like multiple pages, some of them are many, many pages. It's a lot to actually grab them and put them in order in a way that I can, like what I've done the whole night, right? All these things that I'm reading to you guys. If you guys knew how many steps it takes to like make it so that they're organized and you can see them and then they're in order, it's a whole thing. So, and depending on how many pages it is, sometimes it takes quite a while. But I'll want to do that so I can read this and it will be, you guys can see it and everything too. And it will be doing it justice. Oh, it was way before. Okay. Yeah. I just can't remember because, again, just time. So tomorrow is the hearing and God only knows what will transpire for that. Yeah. So, and I will cover it, of course. And I'm trying to think I don't know if we're going to have anything else coming on Idaho because I would probably prioritize that. But anyway, I'll just keep an eye. I don't know. Let's see what time, if I can find out what time the hearing is supposed to be actually. Because I may cover it in the evening. Let's just see here. Meanwhile, question for you guys, since we've got so many new members now, love it. Do you guys have any requests for members only videos or live streams or both or any requests? So far for the members only videos, we've got 2 videos, both pertaining to orchids because that's the only thing that had been requested so far. So let me know if you guys have any thoughts on what you'd like to see. It can be whatever. I'm just seeing, why does it never say what time they're going to start in court? See what NBC Boston says. That's funny. The NBC Boston says there's been a flurry of new filings. That's so funny. I use that word all the time in my video descriptions. I don't know if you guys ever even look at the descriptions, but I use that word all the time. I've never seen it anywhere else, but they said flurry. That's really funny. Of course, it doesn't say what time they're starting yet. I love it, right? When it's like, I do a search and it's like, what time does it start? And then like, last Tuesday, it began at 11 a.m. Useless. Anyway, I don't know. We'll see. I have no idea what time it's going to start. Maybe it might start earlier, but 9 a.m. Yeah, last Tuesday it was 11. It said. Last Tuesday it was 11. Let me see. Let me look on here and just see. I'm just going to pull up my phone. And see if like the NBC Boston or whatever has like a thing upcoming, because then it might have a time. Let's see here. March 4th. That's annoying. I can't see it. I can't see it on any of the sites, the news sites. So I don't know. We'll just see. Okay, 9 a.m. Thank you. Okay, thanks, Meg. So most people are going live around 8:45. Yeah. So I mean, again, I don't like putting people in a position where it's like, you know, if everyone else is going live at 8:45, I'm probably not going to be doing that. So, which is fine. I will probably go live in the afternoon or evening with it. And who knows, it might still be going on. I don't know if they're going to be doing a full day, although for a full day, having said that, Judge Bevel's ends court at 4 o'clock. So, so that's good to know that they're going to be doing that at 8:45. Okay. So yeah, lots happening this week. I think they've got a couple other hearings this week as well. Let me know, guys, again. Oh, well, actually, having said that, like I was just going to say, if you guys have any thoughts for members only, but I wanted to also reiterate, like, if you guys want to go through the Karen Reed interview with NBC, I think it's NBC Boston, her long interview thing. Is that something you guys are interested in? Because that could be something that could be fun for like a members only thing. But also for like members only videos too. If there's like anything you are interested in, you know, y'all let me know. And of course, like I said, there's also a thread in the Discord where you guys can post things in there if you have any ideas or requests. The Idaho Court TV one. Yeah, I don't think I was thinking we can do that. And I wasn't necessarily thinking that as like a members only thing. It could be a members only thing. Totally could be. Is that something you guys want to do right now? Because I'm totally down if you guys want to do that and watch that and go through it. I just don't have a live stream set up, but I could create that real quick if you guys want to do that now. Otherwise, we can do that like the next time we cover Idaho stuff. Is that yes for now? How about this? If you guys are, put a 1 in the chat if you guys are like, I want to watch the Court TV Idaho one now. Meg's wide awake. Okay. Wide awake. Heather's putting 1. Okay. Okay. So I hear you guys. Perfect. Okay. So we'll do it. So, sweet. Okay. So I just gotta create the live stream. Awesome. I love it. Okay. I just gotta create the live stream real quick. And then we'll do it. So I don't know, maybe like 5 or 10 minutes. So let me just go create that live stream and we'll do it. I'm excited. I'm really excited. Okay. So awesome. So I'll go ahead and end this one. Your Twiz is sleepy, but he said 1. So I don't know. Are you? I know you're going to want to see this. I know you're going to want to see this because I'll tell you what, they mentioned the gate. They mentioned the gate. They mentioned the gate. I know you're going to want to watch this. You're going to want to see it. You're going to want to watch this because I have some thoughts as it pertains to that. Okay, so let me end this and I'll get that set up. I'll see you guys here in just a second. Love y'all, and I'll go ahead and roll the outro.